another webinar put on by AstenJ, which will cover a wide range of immigration topics. And you're encouraged to put any questions that you might have in the chat box or the Q&A box, and the speakers will try and deal with them at the end of their turn. But we also have extra time for discussing your questions in two panel discussions, one at the end of the morning session and the other at the end of our afternoon session. So we hope we can cover most of your queries in those sessions if we haven't been able to deal with them during the individual speakers' talks. Now, the very first speaker we have is Brenda Efurhievwe of Goldsmiths Chambers, and it's good to see that so many speakers have volunteered to come to us from Goldsmiths Chambers. There's long been a connection with that set, and two of the regular speakers from Goldsmiths, namely Sarah Pinder and Samina Iqbal, are no longer available because they've been promoted to the judiciary. They're both now full-time judges of the first tier and upper tribunals. So it means that they're not only unable to practice as barristers any longer, but they're not even able to participate in these webinars. But fortunately, we have other members of that set, and one of them appearing this morning for the first time is Brenda. And she's got quite a heavy load of stuff to tell us, because what's been going on with the Nationality and Borders Act and the Illegal Migration Act, with the demise of the Rwanda scheme, that's quite a lot. And I better not spend any more time rabbiting on myself, but pass you over now to Brenda. Thank you.
Thank you very much, Richard. Thank you very much, everyone, for attending today's seminar. I'm very excited to be able to share the updates in relation to the currently confusing state of asylum policy. I will firstly try to share my screen to ensure that I can most effectively share my presentation slides. Okay, you should now be able to see the presentation. Hopefully.
Well, I can see it, so I'm sure everybody else
That's
can.
perfect. Thank you very much, Richard. In that case, without further ado, let me start the exciting tale of the current state of the asylum process post-Rwanda. What we'll be discussing today is, of course, the very timely demise of the Rwanda scheme, followed by a look at the Illegal Migration Act amendment regulations from earlier this year, and how they would have affected the current state of the asylum process, with a particular focus on the standard of proof and credibility, ending with a brief look at where we are now and what we may be able to do to assist our clients in getting out of the backlogs, which unfortunately may still remain despite the demise of Rwanda. So a quote which I found very pertinent comes from our Prime Minister, who, when announcing that the scheme was scrapped, mentioned that it was now dead and buried. Well, the question for the future will be, will the Rwanda scheme morph into something else? The new government has confirmed that the Rwanda policy has been scrapped. However, strangely enough, the Safety of Rwanda Act remains in force, despite its constitutional implications and the wide-ranging criticism of the act itself, as it stands in opposition to factual findings and legal findings made by the Supreme Court. Thankfully, on the 22nd of July this year, the new government introduced the Illegal Migration Act amendment regulations, which I will be referring to as the 2024 regulations. Despite the introduction of the 2024 regulations, The Illegal Migration Act remains in force, at least some of the key provisions which entered into force, because as we know, IMA was a very bizarre act which was only ever partially entered into force. NABA, the Nationality, Borders and Asylum Act, on the other hand, remains fully in force. Let's move on to having a look at the 2024 regulations then. They've been in force since the 23rd of July, or in the alternative, they will be in force from the same time as the provision they amend is brought into force. This bizarre, clunky wording is because they affect provisions of IMA, which have yet to be brought into force. So if they were to ever be brought into force, they will instantly be amended by the regs. The regulations, most significantly for our purposes, amend the date of application of the infamous duty to remove under Section 2, subsection 3 of IMA, because this duty will no longer have its retrospective effect. The regulations also remove the retrospective effect of the mandatory inadmissibility under Section 5 and the retrospective effect of Section 6 and the removals process described under it. The regulations also amend Section 30 of IMA, which is in force, relating to restrictions on granting leave to enter or remain, which will now enable the Home Office to actually start making decisions on those asylum claims which were stuck in the backlog. This will involve the claims from made after the 7th of March and onwards. The bar on granting leave will now only apply from the day that Section 2 actually comes into force. There is no more retrospective effect to the ban on obtaining British citizenship under Section 31, which again was of course very concerning for most of us regarding the future of those clients who do obtain refugee status, whether they would ever be able to obtain citizenship. If the Illegal Migration Act is never brought into force, potentially this risk will no longer exist. However, again, the above restrictions may apply if Section 2 enters into force, which leaves us in a very bizarre state. So what does this all mean for Section 2? Well, the duty was thankfully never brought into force. However, the 4 conditions which were listed under Section 2 will still be referred to in other legislation and in other sections of the Act which are in force and remain relevant. For example, Section 30 of IMA, which introduced Section 8AA of the Immigration Act. The retrospective effect of the duty to remove has been scrapped. However, as we know, IMA is yet to be repealed. So what we should all fear is that Section 2 will one day be brought into force, and that it may be brought into force in relation to another scheme. What we see there is the very friendly and interesting meeting which we saw earlier this year between our Prime Minister and Giorgia Meloni in relation to discussions on the Albania migration deal. This is of particular interest to us now, as we see that over the weekend we learned that courts in Italy have ruled the deal counter to European Union law in relation to asylum. It remains to be seen whether, like we have seen with the Rwanda scheme, small tweaks may follow and Italy may attempt to yet again remove asylum seekers to Albania. So unfortunately, much like Section 2 of IMA, this deal remains a potential threat in the future. I'm just reminding everyone of the wording of Section 2 of IMA and the 4 conditions it contains because of their continued relevance to other parts of the Act and other legislation. The conditions remain largely unchanged. They again relate to people who have are in the United Kingdom unlawfully, meaning illegal arrival, and I included a number of examples of what that would entail, or an individual who has arrived without entry clearance, in breach of a deportation order, or an individual who does not have leave to enter or has entered using deception. What has changed among the conditions is the wording of the second condition, meaning that the entry of the individual in question was on or after the day on which the act comes into force for that person. So it's no longer looking backwards. Thirdly, unchanged, the person did not come directly to the UK, including passing through a third country on the way to the UK. As we know, the interpretation of what coming directly means under the Act would be different and counter to case law and travail préparatoire under the Refugee Convention itself, which stated that coming directly would include also passing through other countries very briefly. So we would be attempting to still diverge from the meaning and intention of the Refugee Convention itself. And the last condition that the person requires leave to enter or remain in the UK and does not have it. Moving on to Section 5, very briefly, again, this is not in force, and therefore the mandatory inadmissibility which it proposed to introduce does not apply. However, while the retrospective effect has been removed, if the section comes into force, there is still a possibility that Section 5 might be used in the future. If the section does not come into force, then most asylum claims would simply be inadmissible. However, a suspensive claim would be able to be made in order to challenge such inadmissibility. However, yet again, we cannot really celebrate, as we will see later today or later during my presentation, other inadmissibility provisions remain in force and they would still affect our clients' cases. Turning to the final, most significant amendments introduced under the regulations. Firstly, Section 30, subsection 3 of IMA, which amends Section 8AA of the Immigration Act, removes the retrospective effect, as I mentioned. So we no longer have a retrospective ban on granting leave to enter, leave to remain, significantly indefinite leave to remain, or entry clearance. And Section 31, the amendment removed the retrospective ban on granting citizenship. However, the ban on granting leave will not be in place only until the duty to remove is brought into force. So again, all of these provisions remain looming as a potential threat in the future. We can't fully disregard them yet until IMA is fully repealed, which hopefully may happen in the future. All cases which were previously stuck in the so-called PERMA backlog relating to these provisions, meaning claims made on or after the 7th of March, they will now be decided under the NABA process, which we will discuss shortly. So briefly summarizing this section, what is the effect on the backlog? Well, prior to the 2024 regulations, all claims made after March 2023 were effectively prevented from being processed, as has been admitted by the current government when they were considering the operation of the Home Office. There was no process to effectively separate the claims which could be decided, apart from a few thousand cases of unaccompanied asylum-seeking children. This led to the creation of the PERMA backlog, and the amendments which I've discussed will mean that the Home Office may finally recommence actually granting leave to remain to the March 2023 and onwards cohort. So claimants from this cohort may no longer be stuck in limbo for this reason. However, as we will look at the current state of the asylum process, unfortunately, there are other reasons for claims to still be delayed despite these amendments. So looking at the overall state of the asylum process, it's very useful to consider the Home Office guidance in relation to how they prioritize asylum decision-making. This guidance has not been updated since the introduction of the 2024 regulations. So it is possible that changes will be introduced in the coming months. However, the state of play at present is that prioritization is still split into, pardon me, the following subcategories. There is the legacy casework, which we heard so much about under the Sunak government. This relates to cases lodged before the 28th of June 2022. To give them their due, this part is mostly cleared. I believe there's a couple thousand decisions still outstanding under this legacy casework. The next group of interest to us is the streamlined asylum processing. These are cases which are considered manifestly well-founded. We will have a brief look at what this means. There's a separate group of caseworkers in the dedicated unit which will focus on Albanian claims due to the agreement signed with Albania recently. The claim and the guidance is that these cases are assessed on a case-by-case basis. However, they are all assessed under the clearly unfounded certification under Section 94 of the 2002 Act. One of the last significant groupings is the attempt by the Home Office to cohort groups of asylum claims, which is a double-edged sword. This can be extremely beneficial when a specialized caseworker considers a group of asylum claims, for example, by nationality, or a group of claims where a group of different nationalities is involved, but they share other similarities. For example, somebody who's a specialist in LGBTQ claims. I mentioned this is a double-edged sword because, well, on the one hand, the individual may become very familiar with particular challenges of certain nationalities and be more keen to grant asylum if they are familiar with the country guidance case law. There is a sad possibility that they may become more jaded and less likely to actually consider the credibility of the claim in an unbiased manner. Whether or not the cohorting policy is subject to challenge is a question for the future. It's just an interesting feature of the existing policy. What's also a part of the cohorting scheme is that it uses the asylum questionnaires, which many of us are familiar with, as failure to complete a questionnaire has been used as an excuse to withdraw asylum claims, which has been very concerning. I believe that this has now changed slightly. However, the questionnaires are, of course, required. They have been used to gather further information about the claim following the screening interview, and we have seen many questionnaires from Iraqi and Iranian national clients. There's also a final potential group, which is the possibility that the Home Office will prioritize a case on an individual case-by-case basis, and I will discuss it in more detail a bit later on, as there is an avenue for us to request a case to be prioritized. Looking now in more detail at the streamlined asylum processing, SAP, this can only be used if the claim isn't subject to inadmissibility action. This is now inadmissibility under the existing older processes. I will look at them in more details shortly. SAP was intended to process, quote unquote, manifestly well-founded claims. Therefore, if a client is put into this grouping, technically it should be good news. This currently applies to nationals of Afghanistan, Eritrea, Libya, and after the 28th of June, it also applies to Sudan. With slightly more stringent conditions, SAP can apply to Syria and Yemen. However, there has to be sufficient evidence provided and available, and entry into SAP for Syrian and Yemeni asylum seekers will depend on considering exclusion considerations as well, potentially due to risk that the individual will be considered as to whether or not they have engaged in actions which would put them at risk of exclusion from the Refugee Convention, for example. the further feature of SAP is that it is also possible to grant asylum without actually undertaking a full substantive interview, or after a targeted interview, for example, only to confirm nationality, or a shorter interview just to go over a number of substantive questions. There must be no negative indicators or factors requiring further investigation. For example, factors such as criminality or issues of safeguarding. But if those conditions are met, then it is possible for a decision under SAP to be made, and that decision would of course be a grant of asylum. If I understood, the policy would not be applied to refusals of asylum. The individual would then be invited for a full asylum interview if a refusal was being considered, to give them a fair opportunity to put forward their claim. Other cohorts may also be considered under SAP. Individuals who are, for example, more vulnerable, it may be considered that it would be beneficial to allow them to put forward their claim in the questionnaire with no interview or a shorter targeted interview to consider their vulnerability. We will now be looking at the state of the current inadmissibility process, the pre-existing process which remains in force. Which process applies to an asylum seeker will depend on the date of their claim. I feel like I will be repeating that sentence many times today, because many things now depend on the dates. Before the 28th of June 2022, claims which were made before this date, the safe third country inadmissibility decision will be made under paragraphs 3, 4, 5A and B of the immigration rules, which were in force at the time. There is a link in the guidance to the archived immigration rules for ease of reference. I believe that at this stage, the majority, hopefully, of the asylum claims we will see will apply to claims made after the 28th of June 2022. The inadmissibility decisions will be made under sections 80B and 80C of the 2002 Act, and under paragraph 3 to 7F of the immigration rules. All claims which are declared inadmissible will also have to be considered for certification under Schedule 3 of the 2004 Act. Looking at the presentation itself, will focus on the claims which we are most likely to see going forward, which of course is claims made on or after 28th of June 2022. This process requires the Home Office to consider whether or not they should declare a claim inadmissible, where a person has a connection to a safe third country. Again, as I mentioned before, the connection can be under the UK approach very, very tenuous, unfortunately. The Home Office will first consider if a case appears suitable for the inadmissibility process. The size and state of the current inadmissibility backlog suggests to us that many, if not most cases, have been considered as potential candidates for the inadmissibility process, which begs the question, is the process really functioning? So suitable cases will then be sent to the third country unit. And if a case is considered inadmissible under this process, TCU will then issue a notice of intent mentioning a country of return. As we have seen in the recent years, the country of return on thousands of such notices was Rwanda, which was deeply confusing, considering the small number of spaces available even under the Rwanda scheme, when compared to the huge number of notices issued stating Rwanda as the destination of return. If an inadmissibility declaration appears appropriate, the TCU must then seek the agreement of the safe third country for this particular individual to be returned. Now, as we all know, after Rwanda, unless something has changed, the UK has no other safe third country returns agreement at present. This is very significant because there are sadly no rigid timescales when it comes to the inadmissibility process, both prior to the decision and afterwards. I quote a substantial part of the guidance. Please don't be alarmed. I will now not attempt to read out it in its entirety. I'm just flagging it for future reference, as this is extremely significant for individuals who are stuck in the inadmissibility process. Previously, this guidance provided a 6-month period as a guide of how long the process should last. Now, the 6-month period is mentioned still, however, only as a suggestion. The statement is that the process itself should not create a lengthy limbo position, which is significant considering that a lengthy limbo position is exactly where the majority of the claims made after June 2022 have been in. However, the process states that it must be considered whether the inadmissibility decision or affecting removal after the decision can be effected within a reasonable period from inadmissibility action. And the action is then said to have to discontinue if it is not possible to be achieved within a reasonable period. As a general guideline, it is expected that in most cases, safe third countries will agree to admit a person within 6 months of the claim being recorded. However, this is not a firm deadline, as we will see below. There are possibilities where a shorter period would be applicable. The guideline also refers to when a longer period may be applicable, but it is significant. And if a challenge were to be brought, it is possible to point to the guideline and say, well, you're not supposed to create a lengthy limbo position. That is what you're doing. Can you please reconsider the client's position within the inadmissibility process? Under paragraph 345D of the immigration rules, an application may be treated as inadmissible. However, if the Secretary of State believes that removal to a safe third country within a reasonable period is unlikely, as we have seen in the guidance, then the applicant will be admitted for consideration of the claim in the UK. So I wanted to stress the existence of paragraph 345D of the immigration rules because since Brexit, since we had to withdraw from Dublin, removals to safe third countries have dropped drastically. Now that the Rwanda scheme is no more, we have a lack of bilateral removal agreements. It is very likely that this paragraph will remain very significant. It may be possible to challenge why the Secretary of State has not exercised their discretion under paragraph 345D in situations where the applicant should have been admitted for consideration of their claim in the UK because of continuous impossible consideration for actually effective inadmissibility. This, of course, puts the very viability of the current inadmissibility process into question. Of course, this is not legal advice. This will depend on a case-by-case basis. However, I would question whether there may be a merit for potential judicial review challenges to the continued use of the inadmissibility process under the current condition with no potential country of removal in existence. The next section of my presentation will focus on the new and exciting split within the standard of proof. Which standard of proof applies in the asylum process will yet again depend on the date that the claim was made. Date, again, will be extremely significant going forward. Before the 28th of June 2022, the lower standard to which we are all used will apply to both asylum claims and humanitarian protection, human rights claims. This remains unchanged. However, claims made on or after the 28th of June, the standard of proof will differ depending on the type of claim. So this split is as follows. For asylum claims, there will be a mixed approach to standards of proof, as I will discuss in more detail in a second, whereas humanitarian protection claims will still retain the lower standard of proof. Asylum claims under NABA have been considered in a very useful recent upper tribunal decision. The JCK decision can be used as an extremely helpful guide for or template for drafting appeal skeleton arguments, as it clearly sets out how we should be approaching the standard of proof in asylum claims. And the questions will have to be posed expressly and dealt with sequentially. So firstly, the decision maker will have to decide whether on the balance of probabilities, so the higher standard, the claimant has a characteristic which could cause them to fear for one of the five convention reasons. The second question will be whether, again, on the higher standard of a balance of probabilities, the claimant does in fact fear such persecution. So this is the subjective fear test. Now, questions 3 to 5 will be decided on the lower standard of proof of a reasonable degree of likelihood. And these questions will relate to the objective existence of the risk of harm, the absence of state protection, and the possibility of internal relocation. So, like I mentioned, the JCK template would be very useful for all practitioners to refer to when explaining to the tribunal how the standard of proof should be applied in the case. It should also be useful. It would also be useful in witness statements. It's very important to know the distinction between the two standards of proof because, again, confusingly under NABA, balance of probabilities will apply to the convention reasons and subjective fear. However, the lower standard will apply to risk of harm, sufficiency of protection, and internal relocation. And this is, again, why it's so crucial for us to focus on the date that a claim for asylum has been made. Thankfully, the situation is slightly less complex in relation to humanitarian protection claims. The reasonable degree of likelihood standard of proof continues to apply. The same lower standard will apply both before and after the date in question. And what I will note is that this lower standard is, of course, the same as the standard set out under under paragraph 339C of the immigration rules. So the substantial grounds for believing that there is a real risk of serious harm is the reasonable degree of likelihood standard of more than 10%. Current Home Office guidance stresses that there is a need to consider all material facts to the lower standard when assessing the humanitarian protection claim alongside the asylum claim. The reason I stress this because, as we know, Home Office is stretched extremely thin. There is a high turnover. However, they will rely on templates when making asylum decisions. It will be very important to consider the refusal letter carefully to make sure that a new credibility assessment has been made in relation under the lower standard of proof in relation to the humanitarian protection section of the claim. Until now, under the old process, it was very frequent for the Home Office or even the tribunal in their appeal decisions to simply state, and for the same reasons, the humanitarian protection claim is rejected. We now would have to expect to see a full-on new assessment specifically under the lower standard. Because this lower standard will apply to HB claims, it is possible that in claims made after 28th of June 2022, well, refugee status may be refused, but the applicant may succeed on humanitarian protection grounds. Therefore, it will be crucial in appeals to draft a very, very robust humanitarian protection section of the skeleton argument. We will now turn to the credibility section of my presentation. And yet again, credibility assessments will depend on the date of claim to a certain extent. The approach to assessing credibility will be slightly different depending on both the date and the type of claim. So different rules will apply to claims made before and after the 28th of June 22. Slightly different rules will apply to asylum claims and humanitarian protection claims. In my presentation, I will focus on asylum and HP claims made on or after the 28th of June 2022, purely because this may be more useful to practitioners. The focus in the credibility assessment should be on the claim rather than the claimant. I mention this as in many asylum decisions, both refusal letters and unfortunately in some appeals, we see very casual statements towards a focus on the claimant. I recently saw a very robust statement made in a refusal letter referring to the asylum seeker as an extremely unreliable witness, which I stress to you not simply as a funny anecdote, but also as a potential error of law. If such a statement were to be carried on to a decision on appeal, this would actually be an error of law in how the credibility assessment is made, as it wasn't focused properly on the credibility of the claim. Of course, hopefully judges would not make such a mistake. However, challenging such statements from asylum caseworkers may be a frequent occurrence. Statements and evidence provided by the asylum seeker can be accepted by the decision maker if they have sufficient detail and specificity, and if they are internally and externally consistent, for example, consistent with the Home Office SIPIN, and if they are predominantly consistent with other evidence provided by the asylum seeker. Of course, the evidence and statements also have to be considered plausible. As we all know, still all evidence has to be considered in the round, and aside from the indicators we discussed, and general credibility would not be the starting point of the assessment. However, it will still be relevant to a consideration of the benefit of the doubt. This benefit can be utilized because, as we all know, claimants may face difficulties in gathering evidence. Under paragraph 339L of the immigration rules, there is no need for further corroboration if the claimant made a genuine effort to substantiate their claim, if all material factors at the claimant's disposal have been submitted with a satisfactory explanation in relation to any lack of evidence submitted. The other necessary rules would be that statements are considered coherent and plausible, and they are not counter to general information or external evidence, that the claim was lodged at the earliest opportunity, or if it wasn't, if the asylum seeker had a good reason not to lodge their claim at the earliest opportunity. And lastly, general credibility has been established. The reason I mention these possibly tried conditions is that I noticed that the Home Office and presenting officers continuously challenge asylum seekers for lack of corroboration, to the point that it appears that these standard conditions, paragraph 339L, isn't really fully considered by the Home Office, and this sometimes unfortunately translates to the decision made by the tribunal. So again, simply mentioning the lack of duty to provide corroborating evidence on asylum seekers, if these conditions are met, I believe should be mentioned and explored in the skeleton argument very briefly, if possible, to remind the Home Office and the tribunal of this legal basis. Now, extremely briefly, what is the difference with the approach to credibility in humanitarian protection assessments? Well, most assessments in HP claims will follow the exact same structured approach to assessing credibility. As for asylum claims, the only difference being the date again, as HB credibility assessments must be undertaken to the lower standard of proof of real risk, whereas after the date in question, asylum credibility assessments may be subject to a different standard depending on which part of the claim credibility relates to. There was a fairly recent Court of Appeal decision in the case of MAH Egypt, which I have found quite useful in doing appeals, as this decision touched briefly on key aspects of credibility. The Court of Appeal reiterated that credibility must be considered in the context of the relatively low standard of proof. Now, of course, we know that this will only be true for HP claims going forward or asylum claims made before the 28th of June 22. The appellate court must be able to satisfy itself that the fact finder has identified the most relevant pieces of evidence and given sufficient reasons for accepting or rejecting it. This statement may appear very trite. The reason I quote this from a Court of Appeal authority is that this again may be useful when considering making a further appeal, because whether or not the caseworker in the decision letter or whether or not the FTT judge has actually undertaken this approach to considering evidence in their credibility assessment will be significant, and failure to do so would be an appealable error of law. The Court of Appeal in MAH also reaffirmed that there is no requirement for asylum seeker to adduce corroborative evidence. This failure would not automatically damage their credibility, as is frequently suggested by the Home Office. However, again, the absence of corroborating evidence may be of evidential value if it could have been reasonably obtained and there was no good reason not to do so. So again, this is reiterating the known statement of law, however, can be very significant and useful in skeleton arguments. The Court of Appeal in MAH also reiterated that the tribunal of fact should be very cautious before making a finding in relation to the account to be inherently incredible. This quote can be extremely useful when it comes to carefully and sensitively addressing our own Western bias and the fact that we have to focus very heavily when making these credibility assessments on what would be plausible in the context of somebody from a different culture, from a different country, when considering the account provided by the asylum seeker. So this question of context is again brought up. I believe that this quote is very useful to subtly hint to a tribunal or other decision maker that we simply have to put ourselves into the asylum seeker's shoes. Turning now to potential damage to credibility, the infamous Section 8 of the 2004 Act remains largely unchanged under the current state of the asylum process. The requirements, of course, are well known. It must be taken into account as damaging to the claimant's general credibility. For example, any behavior that appears designed or likely to conceal information, mislead, or obstruct the resolution of a claim. Examples of this behavior, which is designed or likely to conceal information or mislead, have been provided, and this is where the slight difference lies. Failure to produce an identity document as opposed to a passport, destruction or alteration of the identity document, failure to answer questions asked by a deciding authority, or failure to take an advantage of an opportunity to make a claim. As I touched on very briefly previously, Emma introduced these changes under Section 62. This section remains unaffected by the 2024 amendment regulations. Therefore, it still applies to Section 8 of the 2004 Act. This section added that acts damaging to an asylum seeker's credibility, they all remain in effect, and that was, for example, the introduction of an identity document as opposed to a passport, and also a clarification that all references to documents include electronic documents. The very unfortunate addition under this section was the introduction of Section 8.3 failure to provide to an immigration officer or Secretary of State, upon request, any information or anything else required in order to access any information stored in electronic form. I stress this change to Section 8 because it doesn't only appear excessive, it is almost a mirror image of legislation used, of anti-terrorism legislation, which has been used not just against terrorism suspects, but also against journalists and human rights activists. The introduction of this requirement as something potentially damaging to an asylum seeker's credibility is extremely, extremely stringent. Hopefully, in the future, this is something that we will see challenged as excessive when it comes to considering whether this is something an asylum seeker fleeing persecution, fleeing state violence can be expected to provide. I also mention this as it relates to the country guidance case of PJAC, which among many other things, indicates that it is now considered to be a requirement if an asylum seeker is relying on Facebook content to substantiate their political activity or another aspect of their claim. Previously, we would have provided screenshots of an asylum seeker's Facebook to either demonstrate their many posts, demonstrate messages. Under the 2022 case of PJAC, it is now considered a standard requirement for an asylum seeker to provide a full download of their Facebook. Many practitioners may be familiar with this. It has been around for a couple of years. The reason I mention that is because I have seen this come up in my recent asylum appeals. It's now a standard response from the Home Office that we should not consider as credible any evidence from Facebook which does not come from a full download of the applicant's Facebook account. This is the minimum expectation, which again, like this section, is extremely invasive to the privacy of a potentially traumatized asylum seeker. Hopefully, again, that requirement will also be challenged in the future, but this is the current state of the law. So after this very depressing introduction, a look at where we are now. Well, there is some optimism because of the regulations introduced in July. A very, very recent Refugee Council report stated that after the Rwanda the current post-Rwanda backlog is now forecast to reach 120,000 cases in January 2025. Why is this good news? Because had it not been for the regulations introduced in July, the projected backlog would have been almost 60,000 cases higher. So the backlog will actually start moving now, which is extremely good news for all involved. Based on previous grant rates, the Refugee Council estimates that around 63,000 of those cases will receive a grant of asylum, which again, very promising. However, the other cases will, of course, have to be considered for an appeal. And as of June 2024, in slightly more concerning news, there have been 33,000, over 33,000 asylum appeals waiting to be processed, which is why personally I still see the majority of my cases relate to claims made before the 2022 date of interest. But it is very encouraging to see that the backlog will slowly but surely start moving. We may expect to see more asylum decisions in the coming months. However, as we all know, delays in decision making unfortunately persist. Uh, there are many opportunities to challenge delays. It is possible to request prioritization of the case. I leave a link in the slides you received, which takes you to the part of the guideline from the Home Office explaining how it is possible to request for a case to be prioritized if there are exceptional or compelling circumstances. It is, of course, also possible to challenge delay to asylum decision making with a judicial review. As we all know, a well-drafted pre-action protocol letter may be able to achieve a response from the Home Office, but the surest way, unfortunately, considering current Home Office practice, is to issue judicial review proceedings if appropriate. We now have admissions in multiple cases from the Home Office that this may motivate them to consider the claims in order for the judicial review to be withdrawn. So we know that while clients may not succeed in their judicial review, as is demonstrated in the next slide, a judicial review may in fact be crucial in or a necessary tool in actually getting a case out of a years-long backlog. As the Home Office has admitted, another practice recently, which was to intentionally delay decisions on claims relating to temporary leave for individuals recognized as victims of trafficking. I see that Richard is probably here to remind me that my time is almost up. So very briefly, I just wanted to point you to a brilliant write-up by Sonia Lenegan of a decision from a persuasive authority, the High Court of Justice in Northern Ireland, which recently, very recently considered dealing with Home Office delays by issuing judicial review proceedings. There are some useful quotes of how this may be approached by courts in the future, which, if we're considering issuing proceedings, I would encourage everyone to have a look at. Thank you very much for your attention. I'm leaving my contact details as the last slide. And I see that there are a number of questions. Richard, would I have a few minutes to try to answer them?
I'm afraid we are now running well behind our schedule. I think I noticed a couple of questions from Agnes Lai, which look quite tricky to me and may take you a while to answer. Could we possibly save them for the discussion panel before lunch?
Of course, I will of course be attending the discussion panel at 12:10. So Agnes, I will have a look at your question and hopefully answer it then. Thank you very much, everyone.
Thank you very much, Brenda. Well, I think without further ado, I'd better start on my slot. Now, I don't have any slides, but hopefully you will all have my course notes, and I'll be expanding on those as I go along. Now, what I've done is simply trawl through the most recent Statement of Changes, HC 217, and pick out a few things which took my fancy as I went along. Now, the introduction starts off, or I should say, the Statement of Changes starts off looking at the introduction to the immigration rules, and it inserts into the introduction slot the definition of parent, which was already introduced elsewhere in January this year. And parent is now defined in a threefold way: biological, legal, and adoptive. And the definition of legal parent has been puzzling me. So maybe somebody can explain, maybe type the answer into the Q&A box. Legal parent includes the birth mother, where the child is not genetically related. Well, that made me think of a surrogate mother, but I don't think a surrogate can be a legal parent. But anyway, there it is. Now, quite a lot of the changes are really minor. For example, you may be surprised to know that you can no longer use Rwanda if you want to convert Mongolian tugriks into pound sterling, but it's there. However, much more important is the introduction of electronic travel authorizations, which are going to be necessary for all non-visa nationals next year. So no longer will non-visa nationals be able just to hop on a plane and come to the UK and use their passports in order to get through immigration control. They will have to have this pre-travel authorization. Now, ETAs have been around for a while already, and the new statement of changes rather tightens up the requirements. So basically, it makes it a bit more restrictive. The Home Office have been prepared to allow overstayers who came with an ETA or just came as visitors and then overstayed to apply in future for ETAs, despite their record of having overstayed. But now, even if they leave voluntarily at their own expense, they won't, because of their overstaying, be eligible for ETAs. They will have to apply for a visa. And the same goes for people who've previously been refused entry as visitors, whether at the port of entry or they made an application for a visa, which was refused. They won't be eligible for ETAs and will have to apply for a visa. And similarly, people who've applied for an ETA and got it, but it's then been cancelled for some reason, well, they won't be able to apply for an ETA in future and will have to apply for a visa. There's a new appendix, Appendix ETA National List, and this lists the nationalities which will require an ETA from January next year. And those are all the nationalities except coming from the EU, the European Free Trade Area, or Switzerland, and their date is April next year, where they all must apply for ETAs. Now, those of you who don't have dealings with diplomats won't have much use for this information, but the diplomatic visa waiver, which has been obtainable by accredited diplomats coming to the UK, has been discontinued, and it's replaced by a new insertion into Appendix Visitor called a diplomatic visa arrangement. So it's an alternative to electronic travel authorizations for the holders of diplomatic passports. Recently, I was asked by a member of the National Assembly of Côte d'Ivoire, who was traveling on a diplomatic passport issued by his government, whether he needed to bother applying for a visa to come to the UK. He was actually on holiday in France. And when he asked me, I thought, well, it's a diplomatic visa. Surely he can come on that. Good thing I checked, because you can't unless you're a diplomat. And I don't know why the government in Côte d'Ivoire was dishing them out to MPs, but this chap wasn't a diplomat. He was a member of their parliament, the National Assembly. So he needed a visa, but he was too late. He was coming for a meeting, and it was too late to get a visa, so he couldn't come. And continuing on this theme, there is another new appendix. In fact, there are only two new appendices in this statement of changes, and this one is called VIP delegate visa. And this is only for heads of state and ministers of government from other countries. And it limits the amount of people that they can have accompany them as bodyguards, secretaries, flunkies, whatever, advisors. And it's 20 for heads of state and 10 for other members of government. Well, perhaps rather more likely to come your way is a change to appendix bereaved partner. Now, they are eligible for indefinite leave to remain on the death of their spouse or partner, unless there are suitability criteria which they can't meet. But of course, it's quite expensive, well, very expensive, to apply for indefinite leave to remain. And no fee waivers are available for indefinite leave applications. So what is the bereaved partner to do if he doesn't have much money? Well, now the Home Office have come to the rescue by making them eligible to apply for fee waivers. But the criterion will be not affordability, as it now is for everything else, like Appendix FM, whether you can afford the fees, but whether paying the fees would make you destitute. So that used to be the criterion, but a couple of years ago it changed for other sorts of application in the light of an upper tribunal case called Ligason, if you remember. So now they don't have to, well, at least they can apply for a fee waiver, but the criteria are rather stricter. Well, now I'm going to come to my main topic. In the explanatory memorandum for HC 217, it comes under the heading Other Minor Changes, but I don't think it's really minor at all. So first of all, there is a wholesale change to a part of Appendix EU, which is headed Other Provisions as to Requirements and Procedure. And so that's between paragraphs EU4 and EU8. Now, EU4 starts off, where a person has been granted limited leave to enter or remain under this appendix, they must continue to meet the eligibility requirements for that leave which they met at the date of application, except for any which related to their dependency as a child, dependent parent, or dependent relative. Well, that leaves quite a lot of other categories in which the eligibility requirements that people met when they first applied under the settlement scheme, they have to show that they have continued to meet those requirements. And this also is stated at another substituted paragraph, paragraph EU8, which says that Annex 2 applies to the consideration by the Secretary of State of a valid application made under this appendix. So I think that's been put in because it's now getting harder to make a valid application if the application is late. Technically, if it's being made after the 30th of June, 2021. Now, it used to be that the Home Office were accepting virtually all late applications, but that changed from the 9th of August last year, and now there have to be good grounds for the lateness. I'll be coming on to that a bit later about the lateness. But anyway, Annex 2 deals with valid applications, so including late applications if they're accepted as having shown reasonable grounds for the lateness. Therefore, that becomes a valid application. But there's an alternative in which Annex 2 applies, and that is to consideration of whether a person granted limited leave continues to meet the eligibility requirements for that leave which they met at the date of application, or meets other eligibility requirements, or the eligibility requirements for indefinite leave. Okay, so let's look at Annex 2. Well, that's also been substituted in its entirety by HC 217. So the heading is consideration of a valid application and of whether eligibility requirements are or continue to be met. So it starts off with the first subparagraph, a valid application made under this appendix, and any issue as to whether a person granted limited leave continues to meet the eligibility requirements for that leave, which they met at the date of application, will be decided on the basis of information provided by the applicant or the person, or information gleaned from another source, including another government department. So the issue of whether a person continues to meet the requirements of the settlement scheme may arise when an application has been made and is treated as valid, or when an application hasn't been made, but an issue arises as to whether a person continues to meet the requirements of the settlement scheme. Now, what might draw the Home Office's attention to whether there is an issue as to whether a person continues to meet the requirements? Well, most often, the issue arises when a partnership breaks up and the British or settled, well, not British, the settled sponsor notifies the Home Office that the relationship has broken up. That's the most common reason why the Home Office find out in the first place. Now, Annex 2 continues for several other paragraphs, and they include provision for the person concerned to be invited by the Home Office to explain their circumstances, to give reasons why they think that they continue to meet the requirements of Appendix EU, perhaps in a different category from the one in which they are currently in. And in fact, I'll just find the piece in the rules themselves, if you'll bear with me. Yes, the Secretary of State may request that they provide further information or evidence that they continue to meet the requirements. He could invite them, or she, I should say, she can invite them to be interviewed in person or on the telephone or by video link. And if the person purports to meet the eligibility requirements for indefinite leave to enter or for limited leave to enter and remain on the basis of a relationship with another person, then the Secretary of State may request that the other person provide information or evidence about their relationship with the person who's being investigated, their residence in the UK, or other things, and invite that person to be interviewed by the Secretary of State on the phone. That's the sponsor, if I can use that expression, the sponsor to be interviewed by the Secretary of State. So Um, this looks like quite an important change in Home Office practice. Now, what prompted the Home Office to make such changes to Appendix EU? Because, in fact, for some time before this statement of changes was published, already the status review unit at the Home Office had been making inquiries of people whom they were aware of, whose relationship with somebody with pre-settled or settled status had broken down. So let me just give you an illustration of what is happening with perhaps a rather unusual case, which I came across myself recently. Now, the applicant for indefinite leave to remain had been in the UK under, first of all, the EEA regulations for a couple of years. And then in 2020, he applied for and got pre-settled status for another 5 years. So anyway, having initially got his EEA residence card in 2018, he was ready after 5 years residence, therefore by 2023, to apply for indefinite leave, although his pre-settled status wasn't due to expire until 2025. So anyway, he made the application, but when he did so, he was refused indefinite leave on the basis that his relationship with his Italian partner had broken down and the couple were living separately. So he exercised his right of appeal against that decision, and he's still waiting for further directions. It's still early days. But in the meantime, he received another communication from the Home Office saying, we are considering whether to curtail your limited leave because we have information that your relationship with your partner has ended and you no longer meet the requirements of Appendix EU. So he was invited to submit evidence or information about his circumstances within 14 days of the date of that letter, which he got from the status review unit. Well, he put in some information, and it was based upon the fact that although he's separated from his Italian partner, who has the 2 children residing with her, they depend on him to provide their maintenance. He's working and he's giving them a generous amount of money each week for their day-to-day living expenses. And he says that if his leave is curtailed, he will lose the right to work and the ability to maintain his children. The Home Office were not sympathetic to this argument. They said that he would not lose the right to work straight away because if he decides to appeal against a negative decision, well, first of all, he would have his leave extended, and also he would be able to go on working in those circumstances. But in any event, this kind of argument won't really work. It's not a human rights argument. A human rights argument isn't going to work at all when it comes to the EU settlement scheme. So anyway, he's now had his pre-settled status curtailed, and he's given notice of appeal against that decision as well. So he'll have to get the 2 decisions that he's appealing against linked because they both obviously involve very similar decisions. what can he do? Because undoubtedly his relationship to his Italian partner has come to an end. Is there any way in which he can appeal successfully against that decision? Well, fortunately, he has two possibilities. One is that he's actually married to his partner, his ex-partner. What they did some time back was to contract a customary marriage in a francophone country in Africa. And this has not been dissolved by a customary divorce. And we can argue that it's still valid under English law. The marriage has not been terminated by divorce. And as far as European law is concerned, it doesn't matter if the couple are estranged and not living together. You'll remember the old ECJ case, Diatta and Land Berlin. Provided the marriage is still officially in existence and hasn't ended in divorce, the non-European spouse continues to be able to avail himself of the protection of European law. There's another possibility, though, and that is the fact that the relationship broke up because of domestic abuse by the female partner. She was beating him up. He's got photographic evidence of his injuries. He's got a doctor's letter. He's got evidence of making a police report. So he could have retained a right of residence by virtue of being a victim of domestic abuse or indeed domestic violence. So he's got two alternatives in which he can argue that he actually continues to be eligible under the EU settlement scheme. Others may not be so lucky. So going on then to the next thing. And that is, if you see after the end of Annex 2 on my course notes, that paragraph EU4 actually has some beneficial provisions for applicants. And these are, in the next three bullet points, that the Secretary of State may extend pre-settled status without the holder of that status asking for it. It can be extended automatically without his having made a valid application. The same can happen with indefinite leave. That can be bestowed on a person without his asking for it, if the Secretary of State is satisfied that he meets the criteria. And they can also still apply on their own if they want to. So they don't have to wait for the Secretary of State to confer indefinite leave out of the goodness of their hearts. They can make their own application for it if they meet the criteria. Okay. Now, moving on to Annex 1 of Appendix EU, there are two changes to the definitions in that annex. One is the definition of child, and it's no longer just the direct descendant under the age of 21 years of somebody else, but also one who has turned 21 years of age since the specified date on the 31st of December 2020. So a child doesn't cease to be regarded as a child under the age of 21 simply because he becomes over the age of 21, provided he was under that age by the end of the transitional period. But there's another change which is less generous, and that is a change to the definition of a required date in respect of joining family members. So those, of course, are the people who were not living in the UK before the end of 2020, but they want to join a sponsor who has got pre-settled or settled status in the UK by virtue of their previous residence in this country. Now, they have been supposed to apply if they come to the UK to join a family member. They're supposed to apply within 3 months of their arrival. But hitherto, the Home Office has waived the fact that they've already come over since the end of 2020, most often as visitors, and have gone back, and then have come again. And so it may be after 1 or 2 prior visits that they put in an application for pre-settled status as having joined a sponsor in the UK. Now, they won't be able to do that in future because it's now a requirement that they make an application under the settlement scheme within 3 months of the date when they first arrived in the UK after the 31st of December 2020. So, what is going to be their fate if they've already been here a couple of times as visitors? Well, it's possible that they could still be allowed to make such an application if the Secretary of State is satisfied by information provided with the application that at the date of application, there are reasonable grounds for the person's delay in making that application. So this looks like something similar to what is already the case with people who've made late applications and are not joining family members, but they should really have done it before the end of June 2021, and they certainly should have done it before the 9th of August 2023. They have to provide reasonable grounds for the lateness of their application. Now, there has been considerable concern expressed among practitioners about the tightened requirements for showing reasonable grounds for a late application. And I would recommend that you get hold of a very useful guide to making a late application, which is available from something called the SAFE project. I read about it in the Free Movement blog. And so it's called the SAFE, S-A-F-E, SAFE project. And if you send them an email, they will provide you, I'm sure, with a copy of their guidance on submitting a late application. Now, I've done a few, in fact, myself. And at first, I was very worried that it wasn't going to succeed. One which I got hold of seemed very likely to succeed because the applicant had severe learning difficulties. That constitutes a good excuse. So she got it with no problem. Her application was considered valid. But I also had 2 brothers who seemed to have a much less strong claim. They'd been living in the UK for donkey's years. They came as children. Their mother had acquired, I think it was French nationality. So they came to join her as very young children. They were, I think, already over 20 when they heard about a new scheme that the Home Office had come up with, which required people to apply for permission to stay, although there'd never been a problem about that before. So one of them had been told that he was eligible for the Windrush scheme. So he trotted along to Lunar House in Croydon and duly made his application. but he was gently told that, in fact, coming from a Francophone African country, he was not a Commonwealth citizen, and the Windrush scheme had absolutely no relevance to him. So he went away and never bothered with anything else. Anyway, finally, the word got round that they really should get onto the settlement scheme. So what was their excuse for applying so late just a few weeks ago? Well, I put in, uh, it seemed to me a bit feeble, but I put in the fact that they'd been here for donkey's years. They came as children, and they simply didn't realize that they should have to apply for something else. Well, lo and behold, the Home Office have accepted that as a reasonable excuse and have treated their applications as valid. So maybe it's not so difficult after all. But of course, it will depend on the circumstances, and there will be times when the person maybe hasn't lived here as long as that, came when they were an adult and should have a much better idea of what's going on. Okay, let me move on then to a couple of other less important things. Appendix student, the amount of money that an overseas student has to have in the bank each month for the first 9 months of their course of studies has gone up, as you can see from the course notes. The definition of a child staying with or joining a non-parent relative, brackets, protection, one of those new appendices which have got very long titles, has got a very useful change for the small number of children who would fall into this category. Now, the category is similar to a very old immigration rule, sometimes called the exclusion undesirable rule, which nowadays can be found at paragraph 2971F. And this says that a relative who is not a parent can be joined by a child if there are serious and compelling family or other considerations which render the child's exclusion undesirable. Now, I had a case a couple of years ago where the sponsor was certainly not a blood relative and could only be a sponsor because he was a relative by marriage. Basically, the children were living in Africa. Their grandmother had adopted them by means of court proceedings in their own country, but that country is not recognized, or rather its adoption orders are not recognized in the UK by virtue of the Recognition of Overseas Adoptions Order 2013. So that wouldn't wash. They had to rely upon paragraph 297. Now, their actual grandfather had died and their grandmother had remarried an Englishman. So he was not their grandfather, but he was related to them through marriage, and that was accepted by the Home Office. That wouldn't work with Appendix CNP, as it's usually abbreviated, because the relative must be a close relative as defined in the interpretation section of the immigration rules. So it wouldn't include somebody who's not a grandparent, but is married to one of the grandparents. So the paragraph 297 goes wider. Of course, with Appendix CNP, the sponsor has to be a refugee or have protection status, humanitarian protection, or asylum. But there's no longer any need to show serious and compelling family or other considerations. That's been deleted from the appendix. Now, finally, I just want to mention that Appendix Continuous Residence has been amended so as to make it crystal clear that the impression that people originally got to a change from an earlier statement of changes, namely that if your application was still pending on the 11th of April 2024, you wouldn't be subjected to the cap on the number of days absence in the previous 10 years that you'd had. You could have absence of any length, and that you would only then have to show absence of no more than 180 days in each year that you were claiming for the 10-year rule. Well, that now has been put definitely to bed, and you can't use that argument because that's not what Appendix Continuous Residence now says. However, I'm trespassing on Rajiv Sharma's territory. He'll be talking about the long residence rule this afternoon. So this looks like a good place for me to stop. Now, the time is actually just before 10 past 11, which is when we're meant to take a coffee break. So maybe I could just answer a couple of your queries now before we take a break. So let me just get my cursor down onto Q&A and see what that says. Oh, another question. Is an electronic travel authorization required by a baby? Is there an age limit for this? No, I don't think there is. I think everybody who's coming to the UK from next year will require some kind of pre-travel authorization, even a baby. Just as you need a visa for a child if you're coming from a visa national country. And this, oh, and also from Agnes, another query, this joining family member provision, does it also apply to those who have been granted a family permit as a joining family member? Or does it only apply to those applying as visitors? Okay, well, it applies to when you arrive in the UK. Okay, so when you arrive in the UK with perhaps uh, um, a family permit in order to join a sponsor who's in the UK. So if you travel on a family permit and you arrive in the UK, you've then got 3 months to apply for pre-settled status. And so if you've already been to the UK as a visitor, you would then be hit by this new provision that you should have applied within 3 months of your first arrival in the UK. And now you've got to give a reason why you're applying late, having already been here before. Okay. Oh, I've got a query from Winston Taylor. If a partner of a person with an ancestral visa is suffering domestic abuse, what protection can she receive if she wishes to leave the relationship? Oh, well, I mean, this has nothing to do with the settlement scheme. Anyone who's here with leave to remain who is a victim of domestic abuse can take refuge in appendix domestic abuse and make an application that way. And let's just see if there's anything earlier here in Q&A. Nope. What about chat? I think there's just time to have a look. Oh, I think that's in the chat as well. Yes, here's a question. Those with a permanent residence permit under the EEA regulations and who missed the deadline to apply for ILR under the settlement scheme, can they still apply for ILR under the EUSS? Yes, they can, and they may well have an acceptable excuse for the lateness, because having already been granted a right of permanent residence under the EEA regulations, they may very well have formed the view that they didn't need to do anything else. So probably somebody in that situation would be accepted as making a valid application for settled status. And now, can a divorced partner of an EU citizen on pre-settled status apply on derivative grounds? Well, it would depend on whether they're eligible uh, as a person with a derivative right to reside, as defined in Annex 1. So basically, it would be somebody who had been married for 3 years to the person with pre-settled or settled status, and they'd lived together with that person. I think for at least 1 year, that was certainly the case with the old Citizens Directive, and dating from the date when the marital relationship was terminated by divorce. So it's possible, but depending on how long the marriage was in existence and they were living together in the UK, or living in the UK anyway, I should say, not necessarily together. How can we ensure our attendance to this course has been registered? Oh, well, you would need to contact AstenJ, and I think everybody who actually applies and pays for their attendance at the webinar will be registered as having attended. But I could maybe ask our host. He's typing an answer now. Fine. Now I think the last one I'm going to deal with, because it is 10 past 11. Can a child in the UK without leave benefit from his father, who has retained rights by virtue of his divorce from his EU partner? Father has pre-settlement. Well, it would depend on the child's status. Was the child born in the UK, or did the child arrive in the UK subsequently and subsequently to his father getting pre-settled status? Well, maybe we could continue with that in the discussion panel after the next speaker. So I think because we're now eating into our break time, we're only supposed to have 10 minutes. So I'll be lenient and give you a little bit longer till 25 past 11, but we'll try and start bang on the dot of 25 past when Julian will be our speaker. So see you shortly, folks. Everybody, the magic hour has come back again, and it's time for us to resume the webinar. And I'm delighted to introduce Julian Norman, who's becoming a familiar face at these webinars, a colleague of Samina Iqbal and also Sarah Pinder of Goldsmiths Chambers, formerly of Goldsmiths Chambers. And she's going to talk to us about Afghanistan. And so without any further ado, over to you, Julian.
Thanks, Richard. And what a pleasure to be back at AstenJ. It's very nice to be a familiar face, although it does feel odd to be here without Sarah and Samina on this particular occasion. So yes, today I'm talking about Afghanistan. It's unusual for me to do a talk about a particular place rather than a change to the rules or a change to statute. But there are now so many interesting issues arising in respect of applications from Afghanistan. And of course, they do have their very own section under the rules and an appendix of those immigration rules. It has become quite complicated recently, and I thought it would be worth looking at this as a topic in its own right for today. So I'm just going to see if I can share my screen with everybody. Bear with me, this is always the technical bit. Right, now I think... bear with me for a moment, everybody, because that has started it sharing on the wrong place. What I think I'm going to have to do is just share this one screen and see if that works. Bear with me. All right, is everybody now able to see a keynote screen showing applications from Afghanistan on the title?
Yes, that's up there.
Excellent. All right, well, I'll leave it like that because if I press play, I think it will show on both of my screens and then I won't have my notes, which would make this talk far less coherent than it's intended to be. So hopefully everybody is able to see that there. So what we want to look at today are the available routes for Afghan nationals. I'm sure participants will remember there's been a lot of talk, both from the previous government and from the current one, about safe and legal routes. And one of the routes available to Afghan nationals is intended to be one of those safe and legal routes for applicants to arrive by. I'm also going to look at some peripheral issues. So one of those is unaccompanied children, because for those who do not travel via the ARAP or the alternative route available for people to enter from Afghanistan more directly, we do have quite a large number of Afghan nationals who are in that grey area between being obviously children and obviously adults. And that is a situation which requires quite a deal of skill as well as knowledge of the rules and of course a compassionate approach, because when you're doing the client care element for those for that cohort, it's obviously preferable always to treat them as children, notwithstanding that the Home Office are seeking to treat them as adults. Family reunion is also a particularly interesting issue for Afghan applications because not all of them will be recognised refugees. And then finally, we're going to look at applications for biometric excuse. Now, it's worth saying that that's not exclusive to applicants who have come from Afghanistan. Obviously, people are also applying for biometric excuse from other countries and other areas. So let's look at the available routes for Afghan nationals. The one that most people will be familiar with, if you're familiar with it at all, is the Appendix ARAP, Afghan Relocation and Assistance Policy. Now, this is a route by which people can apply and bring a partner and dependent children. So it's intended to be a route that precludes the need for a subsequent family reunion application because the whole family can travel as a group. However, when we look at eligibility, we see that there are some relatively strict requirements going on there and ones which take a degree of explanation. This is not an application, although I suppose these days how many are but it's not the type of application where one can simply tick off, tick, 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 yes, we meet that, we've got the finances, we've got the accommodation, here is our undertaking, there we go, everything's sorted. It's one that will need a certain amount of application and time invested in things like witness statements, trying to get evidence from abroad if necessary. And curiously, it is not done on application directly to the Home Office at first. How could that possibly work? I hear you ask. Well, the application is first made to the Ministry of Defence, and they decide whether or not the applicant is an eligible Afghan citizen, and then by extension, an eligible dependent. So the first person that you need to deal with eligibility for is the applicant themselves. And if they are considered by the Ministry of Defence to be eligible for relocation to the UK, then it's not the applicant who makes the application, and it's not you who makes the application. The MOD then make the application on behalf of them, and if they are an eligible citizen, are required to do so. So what are the requirements that arise here? So in order to meet the requirements, you have to meet the suitability requirements, of course. So it mustn't fall for refusal under Part 9. That was very straightforward. I know that we've had webinars on Part 9 and the grounds for refusal here previously. So that's just the standard Part 9 suitability issues. And then we go on to eligibility. So a person meets the ARAP requirements if they meet the requirements in 3.1 to 3.6 of the appendix, and 3.7 doesn't apply. Well, let's look at those sort of individually one by one. So 3.1, to be eligible, the person must have applied to and received from the MOD a decision that the requirements are met, so the ARAP eligibility decision. And in this regard, it's almost, I'm not going to say it's a direct analogy because it doesn't quite translate, but it's almost similar to a certificate of sponsorship from a company. You meet the requirements if you hold the COS. Likewise, if the MOD have made the eligibility decision, you meet the requirements. Similar, I think, on the exceptional talent. Once you've got your certificate from another external body, that is met. And so ARAP 3 sets out what those requirements are. The eligible citizen must be an Afghan citizen, aged 18 or over, and must meet these one of 3.3 to 3.6. So we're looking at 3.3 here. We've got our applicant. We're looking at whether or not we should be suggesting to them that they are an eligible citizen. So they meet the eligibility requirement if they submit an application on or after the 1st of April 21, and at least one of the following applies: either a high and imminent risk of threat to life, former employees eligible for relocation, and special cases. Now, 3.4, you might think high and imminent risk of threat to life. You might think that's fairly persistent throughout Afghanistan at the moment. But when we look at that particular requirement, they meet it if they were at any time on or after 1st of October 2001 directly employed in Afghanistan by a UK government department. And because of that employment, there's a high and imminent risk of threat to life. So it is very much exclusively restricted to those who assisted the British government at that time. And it must be directly employed by a UK government department. Subcontractors and subcontractors would not meet that requirement. 3.5, and I hope everybody can still see this because it's not the full screen there, meets the requirements if they were directly employed in Afghanistan by UK government departments, so very similar there to 3.4, or provided linguistic services to or for the benefit of members of the UK's armed forces. And so that's those who were directly employed and translators. And then there's an and. The nature of the role in which the person was employed was such that the UK's operations in Afghanistan would have been materially less efficient or materially less successful if a role or roles of that nature had not been performed. So you can see, if anybody was wondering why it is that it's MOD who are going to be making this assessment and not somebody sitting in Croydon, that probably answers that question, because the issue of whether the operations in Afghanistan would have been materially less efficient or materially less successful without a particularly employed individual or translator is obviously a question that only the MOD can answer. Then there's another and. The nature of the role exposed the person to being publicly recognised as having performed that role. That may perhaps be slightly less difficult to answer because if somebody's identity became known as assisting the UK forces, then that would expose them to risk. And then as a result of that public recognition, the person's safety is at risk. So were they exposed to risk? Are they now at risk? So quite a stiff and stringent set of requirements to meet. Then we've got 3.6, meets the requirement if 1 and 2, and either 3 or 4 or both 3 and 4 applies. So we've got directly employed by a UK government department or provided goods and services in Afghanistan under contract. So this is where contractors can come in. Or worked in Afghanistan alongside a UK government department in partnership with or closely supporting and assisting. So we've got a little bit more room here for more for a wider cohort of people. So that's condition 1. Condition 2 is that in the course of that employment or work, they made a substantive and positive contribution towards the achievement of the UK government's military objectives or national security objectives. And again, this is something which MOD are likely to be able to answer in a way that a Croydon caseworker simply would not have the information available to them to answer that. So we can see its conditions 1 and 2 must be met, not 1 or 2, but both of those. So condition 1 widens it out. And as the saying goes, what one hand gives, the other hand takes away. So condition 1 opens it out a little and condition 2 restricts it back in again. And then either 3 or 4 or both must be met as well. So as a result of all of this, they are or were at elevated risk of targeted attacks and high risk of death or serious injury, or they hold information, the disclosure of which would give rise to or aggravate a specific threat to a UK government department or its interests. So you can see that the ARAP route is highly restricted to those who were relatively senior or relatively well informed within the contractual operations and the military operations of the UK military forces of that time. So when we talk about safe and legal routes, as I did at the beginning of this talk, this is absolutely not a catch-all for every Afghan citizen who is at risk from the Taliban or from any other actor in Afghanistan. It's very, very highly specific. Now, the alternative pathway, which I'm only going to speak about very briefly for the extremely simple reason that it's closed, is ACRS. Now, this is not application-based. And this allowed eligible people to be referred. So again, no direct application. You cannot go to the embassy, enroll your biometrics and say, I would like to apply under ACRS. But there were these three pathways available. The first was vulnerable and at-risk individuals who arrived or should have arrived under the evacuation programme. You may have be familiar with that under its name, Operation Pitting. That was the people who were evacuated from Afghanistan in or around August 2021. Then you've got referrals from the UNHCR, vulnerable Afghan refugees outside Afghanistan. Now, this is one in which the wheels of the UNHCR grind slowly, but in theory, they will make those referrals for people who meet their specific eligibility criteria, which can be found on their website. And then pathway 3 is those who are considered to be particularly at risk. That includes women and girls. Obviously, more recently, that's even more of an issue, LGBT people, and those who supported the UK. So, for example, contractors who were not directly employed by the UK government or the military forces, but rather may have been involved with British Council or similar. Now, why do I tell you that when it's all closed? You ask, well, the answer is that the separated families pathway remains open. So this, the separated families pathway, you've got pathways 1, 2, and 3. Well, what about the families of those who entered, particularly under pathway 1, and that is the separated families pathway. And I will talk more about that when we look at family reunion. So let's move on then to unaccompanied children. Obviously, there are still people coming in without permission to enter, either on small boats or other methods. And a number of those will be Afghan nationals, because as I've said, the Arab pathway, ACRS, those are not open to direct applications from anybody, and they are highly restricted in terms of who is entitled to be referred, either under ACRS or alternatively through MOD to Arab. So we do still have age disputed Afghan nationals sort of coming through the system. They will be treated as adults if they are considered to be clearly over 25. If they are considered to be in a grey area, someone who might be between 16 and 25, they should be given a full Merton compliant age assessment process that they can go through, and that again is open to challenge. This is done by way of judicial review, and of course with any judicial review proceedings, and including these, it is possible to ask for interim relief pending resolution of the judicial review. So if you have, if you're arguing that somebody's Merton compliant age assessment in that 16 to 25-year-old bracket was not in fact Merton compliant and should be redone or reevaluated, you can ask for interim relief for them to be treated as a child pending that resolution. There is a fairly recent key case, Crown on the application of HAM. The citation number is there, 2022 EWHC 1924. So when I say recent, I mean, it is 2 years old, but recent in the great scheme of things. And I've put that in there because it gives an extremely helpful summary of how these processes are and how they should be carried out. And these are difficult to work with because on the one hand, everybody agrees that somebody's physical appearance and demeanour is a massively poor indication of how old they are. Yeah, we all remember, I'm sure, a case in the newspapers a few years ago, an individual who was convicted of a very serious sexual offence, and his defence was, well, he had no idea that the girl was in fact as young as she was because she was in an over 18s nightclub. So that was obviously somebody who looked much, much, much older, perhaps, than she was. And equally, we will all be familiar with people who say that they continue to be asked for identification buying a bottle of wine in the supermarket when they're 35 years old. Physical appearance and demeanour are just terrible ways to assess how old somebody is. But if they enter the UK with no documents, no obvious identification at all, then the courts have said, well, you are entitled to have regard to it if there is no other evidence of how old somebody is, because realistically, what else have you got to go on? Now, they didn't put it quite like that. I am, of course, butchering Mr. Justice Swift's beautiful judgment there by seeking to summarise it quite like that. But these are really technical matters. And of course, the difficulty with judicial review is that you're always asking not, is the decision right? Because the decision might not be right. The decision might be completely wrong. You're asking, was the decision lawful? Was it open to the decision maker to make it? But you should be entitled to also say to the court, not just was it irrational, but also should the applicant be entitled to a reassessment, essentially, in the upper tribunal. So if you are dealing with those types of cases, then Crown on the application of HAM is a useful one in terms of setting out what the correct approach should be. And for those who do want to use that, that's set out at paragraphs 24 onwards. So what about family reunion? And we're talking now about all applicants from Afghanistan. And that includes those who have come without leave. It also includes those, including those in the category of family reunion, who came under ARAP or under ACRS. Strictly speaking, those are not family reunion cases, as we are about to see. So, standard family reunion. We all know about this. We've all dealt with them. Appendix family reunion protection in the immigration rules. Do you have a pre-existing spouse and minor children? Are you in the UK with protection? Reasonably straightforward. Obviously, there will always be hard cases. There will always be edge cases, which need a little bit more in the way of analysis. But broadly speaking, for standard refugee family reunion, it's governed by Appendix family reunion, and it's reasonably straightforward. But if you are dealing with somebody who is in the UK, settled, who came through the ARAP scheme, they will have settlement under either ACRS, which is outside the rules altogether, or under ARAP, which is within the rules. That leads to indefinite leave not to protection status. So before you leap in there and say, oh, well, you must be a refugee from Afghanistan, let's use the family reunion rules, bear in mind that you might not. Because if they've come under those routes, they're not entitled to apply for family reunion under Appendix family reunion. So what can we do? So on ARAP, obviously the ideal situation is that the application by family members can be made at the same time as the main applicant, or alternatively, it can be made, if necessary, after the main applicant. Ideally, you would want to do, the whole family would be applying together, and then there is obviously no need separately to make the application. But straightforward cases do not require our services. as much as those which are not straightforward. So you may well see people who are making applications for family members to enter. It's essentially the same criteria for the dependents as it is for the main applicant. It envisages a partner or children, and the criteria for partner or children is essentially going to be the same one as the one for the eligible citizen. Did the eligible citizen meet those requirements? If yes, and the MOD have made the referral, then their family members are likely to be entitled as well. So they must provide biometrics and so on, and they must be a partner, child, or eligible family member. Again, Part 9 applies, suitability, and relationship requirements as a partner will almost always be a spouse. The child must be under 18 on the date of application, must be dependent, so the usual more familiar family reunion criteria there. The criteria which become more difficult is in relation to an additional family member. So obviously, Afghanistan having been in and out of conflict situations for some considerable time, you do get situations where somebody is caring for their nieces and nephews, or a cousin's children, or a brother-in-law, sister-in-law who may have disabilities, something like that. So when you look at additional family member, firstly, it can't be an additional partner. So you only get one partner under these rules. Secondly, the additional family member must meet at least one of the following requirements. Number one, as a result of the eligible citizen's work for or with a UK government department, the applicant, so this is the extended family member or additional family member, must be at elevated risk of targeted attacks, specific threats, or intimidation, putting them at a high risk of death or serious injury. So this is where the eligible citizen has undertaken this work. They are themselves at such high risk in all likelihood. And then we have an additional family member who is themselves at risk because of the eligible Afghan citizens' work. Now, that does raise a question in terms of, well, if somebody is from a family which has supported the British over that period of time, what happens if the brother-in-law or whoever it may be has themselves acquired a profile for whatever they've been doing, yet they themselves are not an eligible citizen? And that's one which is genuinely difficult to assess, because it's difficult to tease out if somebody is from a family that is at risk or at elevated risk. To what extent can you directly attribute it to one person's activity rather than multiple persons' activities? So that's one just to be aware of. The second criteria for an additional family member, and perhaps in practice the more likely one, is that the applicant must face specific vulnerabilities which have led to an exceptional level of family dependence and would be unable, even with the practical and financial help of the eligible Afghan citizen or their partner, to obtain the required level of care or protection outside the UK, either because it is not available and there is no other person who can provide it, or because it's not affordable. So this is a mash-up, if I can put it that way, of the adult dependent relative rules and the protection rules. But you can well imagine that if somebody has sustained a physical or mental illness during the conflict in Afghanistan, they may well have an exceptional level of family dependence. And those specific vulnerabilities, again, supported by relevant evidence, you could, in those circumstances, recommend to your client that they should approach MOD with that. And then where the additional family member is a child, the eligible citizen or their partner must be the legal guardian, or one parent is a person who's British or settled here, or will be ordinarily resident here. So, for example, you've got somebody, the additional family member is a brother-in-law, sister-in-law with particular vulnerabilities. Their child would then be eligible under that if they are under 18, or the serious and compelling reasons. So quite a hefty chunk there of law to consider if you're approached with a request to look at whether or not somebody is eligible for family reunion. You know, can I bring these additional family members? And then we've got the ACRS separated families pathway. So this is for those evacuated between 13th and 28th of August 21. So this is ACRS pathway 1, the evacuees under Operation Pitting. It covers the partner and any children who were born on or after the 28th of August 2003. That is for adult evacuees, so those who were 18 or over when they were evacuated under Operation Pitting. However, some people who came on that ACRS pathway 1 between those two relevant dates were children. So they were themselves young people. Very often the intention had been to evacuate them with their parents, but in the chaos that ensued, the children came to the UK, the parents were left stranded either in Afghanistan, or they've sometimes managed to get to other countries. Now, I think that almost everybody who is going to apply in this category will have done so. But if you have anybody who you're dealing with who's umming and erring about whether they're eligible, be aware that the referrals for this are only open until the 30th of October. That is next week. So it's a time-limited issue. It doesn't really apply for ACRS pathways 2 and 3, because pathway 2 leads to refugee status. If you've got refugee status, you can apply under the standard family reunion protection appendix. And pathway 3, you either bring dependent family members at the time of the application or apply under Appendix FM in the usual way. So that's the family reunion and family reunification, I should probably call it, routes for those applications. And then the last thing that I want to talk about is biometric excuse or predetermination. It sounds a little bit like the title of some theological tome, but it is in fact all about safe travel to a visa application centre. So in the context of Afghanistan, for example, you might have somebody who either was evacuated under ACRS pathway 1, or you might have somebody who is here on ARAP, or somebody who's here seeking family reunion under some other route. But the spouse and minor children are going to struggle to get to a biometric centre, because I think the nearest one, to my knowledge, is Iran. How are they going to get there? How are they going to travel safely through the territories that they need to travel through, particularly if it's a wife and minor children? Does she have a chaperone? Can she find one anywhere? If it's just minor children, there might not be an adult who is a parent or guardian. We might be talking about children aged 17, 15 and 13, for example. How are they going to navigate the practical difficulties of getting to a visa application centre enrolling their biometrics, travelling home and waiting for a decision without encountering very serious harm, which obviously can arise in these situations. And as I said, this is not just for Afghanistan, this can be applied to other countries too. So there's two things that can be done in that situation. The first is to ask for the application to be predetermined prior to enrolment of biometrics. So essentially what you are saying is, look, if I were to make this application, or I am making this application, what would your answer be? Because if the answer is no, I'm not going to attempt to make this treacherous journey. The alternative is to say, well, can you just excuse me from the requirement to enroll my biometrics and I'll do it when I get to the UK, which is known as a biometric excuse. Now, I think that this is something that that perhaps sounds more of an option on paper than it is in reality, because the guidance makes clear that it is quite a high threshold. We're on version 4.0 at the moment. It was last updated 26th of September 2024. You'll find it on the government website, and it's entitled Unable to Travel to a Visa Application Centre to Enrol Biometrics, brackets overseas applications. Not a snappy title, but it does do what it says. So this explains in what circumstances they would consider requests for predetermination or for biometric excuse. And they do make clear that before even making the application, before even getting in touch, individuals are expected to explore whether they have alternative options. Can they delay their journey until it is safe to travel? Well, that's going to depend very much on the situation that they're in and which country they're in. Can they use an alternative VAC that they can safely travel to? Can they pay for a priority visa or super priority visa where available, so that they can make the journey just the once, get the decision and move straight on? Or use the keep my passport while applying if they need to travel back. And they say if you can use one or more of those options, then do so. And they also say in most circumstances, having to travel to a third country is not a reason they would predetermine or agree a biometric excuse. They do have to follow the online application process. And you will see in the guidance, if you go through it, how that is done. And in terms of the principles, the principle against which the individual's right is being balanced is public protection and the risk to national and border security, where somebody enters without having already done biometrics. And they say that's because you won't be able to undertake a full range of background suitability checks until the person has enrolled their biometric information. So in terms of considering requests, there are 4 criteria. Firstly, you need to satisfy the decision maker as to your client's identity to a reasonable degree of certainty. So it is never, ever going to be enough to send a quick application saying, it's very dangerous where my client is from, please predetermine or grant a biometric excuse. It will have to be supported by, here is evidence of their nationality and identity. And that might be copies of passports, birth certificates, the usual. If it's family reunion, you could consider DNA, although whether that's available to somebody who is in a situation where they need biometric excuse, you would have to explore. They would also have to provide evidence that they're required to make an urgent journey to a VAC that is unsafe, and that they cannot delay their journey until later or use alternative routes. And the circumstances must go beyond simply wanting to join relatives. For example, the UK-based sponsor requires full-time care and there are no other viable alternatives. And then that's set out. I'm conscious of time, so I won't go into too much detail, but it's all set out within that guidance on the website. Obviously, for those who are able to meet the criteria, this is absolutely crucial, because it means that people who would not otherwise be able to enter the UK on family reunion or whatever other route it is, are now able to do so without risk to life and limb that arises from trying to travel across dangerous territories. The difficulty is that there is an increasing number of applications. It may be that it will take so long as to be counterproductive before they even get the decision as to whether their application for biometric excuse has been granted. And bear in mind that at the moment, the Home Office are not extending time. So if you've got 6 months to enrol your biometrics, if you ask for a biometric excuse and they come back 5.5 months later and say no, you've then got 2 weeks to get across your dangerous territory and abroad to enrol. So that's something to bear in mind as well, that if it is a no, it may be a delayed no, you may have to reapply, which obviously will cause further delay yet again. And then the other thing to be aware of is always check the guidance, because it is updated reasonably frequently. So that is the end of everything that I was going to say about these applications. Obviously, it's an absolutely enormous topic. There is existing case law on the biometric excuse for those who are interested in that. I'll just give you one citation, which is MRS and FS. It's 2023 UKUT 85 brackets IAC. Absolutely unlikely to be the last word, but for those who want to have a little look through that, there are some interesting points within it. So that's I will stop there. So I can see Richard coming back on, and I think that we have now a panel discussion, so I will stop sharing. Thank you very much, everyone.
Thank you very much, Julian, for that very thorough and comprehensive discussion of the Afghanistan problems. No, you're quite right. We do have a half-hour slot in which people can put further questions, or we can catch up with questions that have already landed in the Q&A box. And I wonder if I can just have a look at the Q&A box myself, because I think there are 1 or 2 questions which I didn't answer at the end of my slot. And perhaps I could go through them first of all, and then we'll see what else there is. Okay. Well, from an anonymous attendee, there's a question: can a divorced partner of an EU citizen on pre-settled status apply on derivative grounds? So I'm not sure if that means that the divorced partner has pre-settled status, or if it's the EU citizen who has pre-settled status. Anyway, perhaps the anonymous attendee can explain that. I'll continue with a query from Regina Idu. Can a child in the UK without leave benefit from his father, who has retained rights by virtue of his divorce from his EU partner? Father has pre-settlement. I don't think the child can benefit. Now, if the father was an EEA national and he had pre-settled status, he could be joined by his son under Appendix FM, or at least an application could be made with a fee, of course. But as the father is not an EEA national, I don't think the child can apply under the settlement scheme. What do my colleagues think of that?
I agree with that, but I do think that an application outside the rules would probably have quite a decent prospect of success if the reality is that his relationship with his father would be completely disrupted while he expected to leave the UK. And it might be that the father, if the father has custody of the child, it depends whether he could be expected to return to both of their countries of nationality if it's the same country of nationality. And it depends what ties the father also has. But if there's a mother, a parent as well, and the child has contact with both parents, then it might be sensible in those situations to get the any contact formalised by way of a court order in the family court, which will make clear where the child is expected to be and in what circumstances. So if he has to be made available for contact with the mother, for example, every Saturday, he can't do that from a non-EA country.
Oh, thank you for that very comprehensive reply. Brenda, would you like to add anything to that?
No, I think it was sufficient, more than sufficiently comprehensive, so I absolutely have nothing further. Thank you for that, both.
Fine. Okay, the next question is, from Subiraj Sajor. Even if the vignette of permanent residence in their passport expired 2 to 3 years ago. I think this follows on from a previous question about whether somebody who had acquired a permanent right of residence under the EEA regulations would be eligible under the settlement scheme. And well, the right to reside permanently in the UK would actually have expired at the end of 2020, regardless of what was in the passport. But the fact that the person had acquired that right would have enabled that person to apply under the settlement scheme for settled status. Now, it wasn't made in time. It wasn't made by the end of June 2020, but it could be still applied for late if there's a good reason for the lateness. So I think that's the situation. It's still possible to apply for settled status, but giving a reason why it's taken so long to apply.
If I could maybe add to that, I think it would also be pertinent whether this person left the UK since the vignette, the passport expired. I'm not sure if that was addressed in the first part of the question earlier.
Oh, no, it wasn't. I think it was just, let me just scroll up a little bit. Yes, the original question was those with permanent residence under the EEA regulations and who missed the deadline to apply for ILR under the EUSS, can they still apply for ILR under the EUSS? And, it says Julian Norman would like to answer this question. So I better turn to her.
I was keeping on top of the admin, Richard, by clicking answer live because you were answering it. I didn't realize it was going to then tell you that I was answering it.
Oh.
I've been doing that as well.
But yeah, I think you can still make an out of time application if there's good reason to do so. And I don't know whether there's ever been a case looking at whether if you have indefinite leave, settled status, can that simply be whisked away from you, or do you still have it? Because I have to confess I've never fully understood how it is possible that somebody who has indefinite leave suddenly doesn't have indefinite leave post-Brexit, because the recognition of that permanent right of residence, in the same way as if somebody has tier one investor indefinite leave, that's a route that doesn't exist anymore either. It doesn't mean that their leave goes pop. But I'm perhaps thinking too far outside the box with that one. So for the purposes of this question, I think you can make the application and see what happens.
Yes. Actually, it's a very interesting point because although settled status is the equivalent of indefinite leave to remain, is it actually completely equivalent? Or because if it is, then there should be no need at all for somebody who's got a permanent residence under the EEA regulations to apply for anything else. So there would be no obligation whatever on this person to apply for settled status under the EU SS scheme because she already has indefinite leave. And that can't be taken away, unless it's revoked for criminality or whatever. But
I think that's, pardon me.
oh, go ahead.
Thank you, Richard. I think that's why it would be relevant if this individual has remained in the UK with their permanent residence. I know that some EU nationals have received a separate permanent residence booklet, and I know that not as a practitioner, but because I used to be an EU permanent resident. And this would expire only if you remained outside of the UK for, I think, over a year. Therefore, the permanent residence, which would entitle them to then apply for nationality, should still be intact as long as they didn't, like you mentioned, engage in criminality or weren't outside of the UK for too long. There may be a possibility that this person is actually entitled to apply for citizenship. So, very interesting case study. Thank you for the question, Subiraj.
Yes. If you've got settled status, you can be absent for up to 5 years, can't you, without
Up to
losing
5
that
years. Yes, you're
status?
correct.
But it would be 2 years for ordinary indefinite leave.
Mhm.
That
I don't
expired
remember
after
what
2 years
permanent
absent.
residence stated, I have to admit, because I immediately applied for citizenship.
Mm.
But yes.
Well, I think just to stick to the question, yes, you can apply for settled status, and but you would be subject to this requirement to give a good reason for the lateness. Though what the repercussions might be if you don't apply, or if you're not eligible to apply for settled status, how would that affect your pre-existing permanent residence? That's a good question, and well, yeah, I think we just have to leave it at that. It would require a bit of research, I think, to give a definitive answer.
From
No.
what I recall from the EEA regulations, it was equivalent because it meant that you were free from immigration control, which is the criteria for ILR. But there may be something, because obviously it's not something I've researched properly. There may be something that I'm missing.
Yes. Yes. Well, there is this difference between the length of time you can be absent from the UK with ordinary indefinite leave and with settled status. I don't know if there's anything else to distinguish the two. Anyway, let's go on to a question from Adeni Adewoye. Can a non-EA national benefit from the EUSS provisions if they formed a relationship after the cutoff date? If the EEA national was present in the UK before the date, if the relationship wasn't formed until after the cutoff date, they couldn't apply under the settlement scheme. I mean, if they're partners now, but the partnership only arose after the end of 2020, the non-EEA national would not be eligible under the scheme, I don't think. Yeah, because the relationship has to predate the end of the end of 2020. Okay.
Yeah, I completely
So it doesn't
agree.
matter if the EEA national was in the UK themselves before the end of 2020, but if it was a durable partnership and the non-EEA national was in the UK, that could. But then actually you would need docu a documented residence card, wouldn't you, if you were a durable partner in the UK before the end of 2020? You can't rely on it, even if you were actually living together, but you hadn't got an EEA residence card at that point. And this is somebody who didn't even form the relationship until after the end of 2020. So I don't think they have any chance of making an application successfully. Okay. Well, just going down a wee bit. Regina, the child came as a visitor. Oh, I think this is to join the father. Yeah, I think that's continuing from that. And then from Subiraj Sujor again. Oh, this is again about people who did have permanent residence applying for settled status. Yes, I'm sure they can still apply for ILR under the settlement scheme. And going down a bit, Abadur Baba. Oh, thanks. He may be replying to Wasanta, who told us that yes, if you're registered here for the webinar, you'll be registered for all purposes. Okay.
I've seen one, Richard, which I've accidentally typed a question to and has transferred it into the answered questions box from an anonymous attendee. A client who has British nationality and settled in the UK for several years wishes to bring his widow mother, who has depression and lives with other family members, to join him. Would we have to apply under adult dependent route for non-visa nationals? And would it be difficult trying to get evidence of her medical status and other hurdles, try and get biometrics done? Well, the anonymous attendee has also added that the mother is in Afghanistan there. Now, my question back to anonymous attendee is she in Afghanistan right now, or is she living in another country with those family members? Because there will be different answers for both. And anonymous attendee, I think that you will find the answer to this one probably better in the adult dependent relatives talk I'm doing this afternoon. The short answer is yes, you do have to apply under the adult dependent relatives route. And evidence of medical status and the acceptability of the living with other family members is something that I'm going to look at in detail later on. So maybe that's a bit of an overlap between the two talks that I'm doing, but I think possibly one for the ADR discussion later.
Yes. Yeah, if the mother is actually residing in Afghanistan, she would have to go to the visa application center in Pakistan, in Islamabad, to make her application. But if she's actually residing in another country, it would depend upon what her circumstances are there in that country. But as you say, we should move on. And Subiraj Sujor, oh dear, I've forgotten what his. Oh, they never left the UK. Yeah, I think that's an answer to Brenda. So this person who acquired permanent residence has been here all the time. Okay. Now, Muhammad Mahfuzur Rahman asks, a person living in the UK for 6 years, but applied for pre-settlement 2 years after that. Let me just scroll up a bit. That means 4 years passed. Can he apply for settlement now, though 1 year left? Oh dear, I'm not sure I've grasped all that. Let's see if I can get back to it. More questions have been coming in. Okay, a person living in the UK for 6 years applied for pre-settlement 2 years after that. 2 years after what? 2 years after starting to live in the UK? Or I wonder if you could be a bit clearer. I really can't quite understand what you're asking here. So if you could send in your question again with a bit more explanation. Now we come to one from Dominda, quite a long question. My client entered the UK as a visitor with her British husband married for 23 years, to get medical treatment for his cancer. After 6 months, she managed to extend her visa as a visitor for 1 year, which is ending in November 2024. The UKVI granting her visa mentioned that they extended her visa on compassionate grounds, on the visitor rules. However, her biometric residence permit says that she was granted spouse visa for 1 year. I believe this is a mistake. Sadly, her husband passed away earlier this year. She now wants to stay here. Is there a possibility? She has in the meantime filed a medical negligence case against, presumably, the hospital, as she believed that the hospital made a mess in treating her late husband. Wow. Well, had he been here on a spouse visa for 1 year, and the husband passed away while she was here with leave to enter as a spouse, she would be eligible to apply for indefinite leave as a bereaved partner. But I think it must be a mistake, because you wouldn't be granted a spouse visa for 1 year. It would be 2.5 years or 33 months rather than 1 year. And if she was here, with a visit visa, which would be valid for 6 months, she could indeed get an extension. I think you have to pay something like nearly £1,000 to get an extension of a visit visa, but it can be granted on compassionate grounds like these. And here it's been done for a year. I don't think the Home Office are bound by the mistake that they made. If it says that on her biometric residence permit. Generally speaking, they're not bound by their mistakes.
They might be.
They might.
I've just had a couple of cases where I've been arguing that they're bound by a mistake on the basis that whilst you cannot have a legitimate expectation of future leave to remain if you're not eligible for it, either because you never were or because you've become ineligible for it, but you can, my tribunal said, have a legitimate expectation that your case has been properly looked at. And the other thing that I think might be useful here is that the bereaved partner requirements, BP 4.1, an applicant must have or have last been granted permission as one of the following, and partner under Appendix FM is one of them. So it doesn't say must correctly have been granted, it says must have last been granted, and if they granted it in error, they still granted it. So I would say it's worth a try. Yeah, if you were to put it in with in the alternative, we would ask for leave on the basis that we are most akin to bereaved partner leave, then you might get a compassionate outcome anyway. But on the face of it, the rule very clearly says must have last been granted, and it's what she was last granted, whether she should have been or not.
Well, she could try applying for indefinite leave as a bereaved partner and maybe apply for a fee waiver before doing that. Yes, and she would also have, I suppose, an extra argument for leave outside the rules if she needs to pursue a negligence claim against the hospital, and she can do that much better from within the UK. But that wouldn't tip the balance, I think, if she isn't to be treated as a bereaved partner. But still, worth a try anyway, I think, for leave outside the rules if she can't do it as a bereaved partner. Does that sound right, Brenda? Yes. Okay. So let's go on down. Oh, Agnes. Okay. I think under Article 15 of the withdrawal agreement, once acquired, the right of permanent residence shall be lost only through absence from the host state for a period exceeding 5 consecutive years. Ah, well, I think that's pretty authoritative. Uh, so I think we can accept that, Agnes. Thank you very much. Okay, so down to the next one. Relating to the earlier question regarding a possible derivative right, which Richard has answered, the divorced partner has pre-settled status. His partner is an EU national. The clarification sought was as to whether these applications are still possible, and the response was in the affirmative. Thank you. Ah. Oh, was this the child who's joined the father in the UK and doesn't have leave? And can the child apply under the settlement scheme? Oh, I think if that's the question, didn't we say that there didn't seem to be the possibility of doing that under the settlement scheme? Hmm. Because I think we were saying that if the father was an EEA national and had pre-settled status, he could be joined by a child, or an application could be made with the usual fee under Appendix FM. But that's not possible for a non-EEA national who's got pre-settled status. So regardless of what is the basis for the pre-settled status, derivative right or whatever, he would, I don't think the child who's in the UK now can apply under the settlement scheme. Oh, well, maybe we can come back to that later. Oh, here's Winston Taylor again. Apologies, but it does not appear that the domestic abuse provisions under Rule 289A. Oh, I think that's the former, more recently, those provisions have been replaced by appendix domestic abuse. So you'd have to look at that appendix now. But whether it covers a person who is the spouse or partner of a person who has limited leave under an ancestral visa. Oh. No, I think you have to have indefinite leave, don't you? Oh, no, sorry, you don't. You have to have leave under Appendix FM, don't you? Rather than as the spouse of somebody with UK ancestry.
You have to have had permission as a partner under Appendix FM, or a spouse, civil partner, or durable partner under Appendix EU, a partner under Appendix FM Part 11, or family reunion of a person with permission if it's a refugee, Appendix Armed Forces, or of a foreign and Commonwealth citizen or member of HM forces, or leave outside the rules previously granted under the Migrant Victims of Domestic Abuse concession. The only other one is as a partner of a person present and settled in the UK under paragraph 285 or 295E of Part 8. And if we look at what that is, because I have to confess, I don't immediately know what 285 of Part 8 might look like. Unless that is it, which it may or may not be. 285 is an extension as a spouse or civil partner under the previous immigration rules. So I don't think that Appendix Domestic Abuse covers ancestry visas.
I think that's
because it wouldn't have been expected that you could settle necessarily.
Yeah, I think that covers it. Well done. Well done indeed, Julian.
Got two screens going on here, so I can quickly check the criteria.
Yes, fine. Yeah, you don't need to check Part 8 very often these days. So what Rule 285 says doesn't spring immediately to mind. Okay, now TT Noah. Oh, no, it was the question about a divorced partner applying on the basis that they had been married for 3 years, lived together for at least 1 year. Okay, whether you could have a derivative right to reside in those circumstances, and you can after divorce. I think that's right. Okay. Now, we've had a question from Mr. Rahman already, and more information on it, I think. An EEA national applied for pre-settlement. Oh, yes, this one. Applied for pre-settlement 4 years before, but in fact, he lives in the UK for 6 years. So he lives here for more than 5 years. Can he apply for settlement status now, though 1 year left from the pre-settlement application? Okay. Well, while the EEA national was residing in the UK up to the end of 2020, he had a right to reside here. Okay, and if he had lived here for 5 years before the end of 2020, he would have acquired a right of permanent residence. Okay. Now, although he may not have applied for a residence certificate during that period, it would still count as lawful residence in the UK under EU law, so he can count it towards his total number of years resident here under EU law. As for applying for settled status now, oh well, does he I think he has pre-settled status. He's got it. Okay. So he can apply for settled status once he's reached a total of 5 years under European law. It could be a combination of leave under the EEA regulations followed by pre-settled status under the settlement scheme. And once the combination results in 5 years residence, he would be eligible for settled status. Yeah, I think that's it. Okay. Now, there's another one from Winston Taylor coming up. Oh, that was my view, unfortunately. Oh, going back to the previous thing about the ancestral visa. Oh, Agnes has a question for Brenda. I'm just interested in hearing, I think that's Brenda's view, not Bred's view, on my questions on stage 1 assessment of credibility that I asked earlier on. Oh, in the hope that we have time for this. Yeah, that was an early question right at the
Yes,
start while
Agnes.
you were giving your talk.
Yes, Agnes, I have actually answered both your questions by typing out my answers, but I'm happy to read them out. The questions disappeared into the answered section of the Q&A, so you may not have seen it. In response to your first question, Agnes, first of all, thank you. Whether the asylum seeker falls under one of the 5 convention reasons will be assessed on the balance of probabilities, and the standard of proof is the only change here. However, how this is evidenced has not changed at all, so you're absolutely right. An inherently coherent, internally consistent statement may still be sufficient, but as long as it would not have been reasonable to expect the asylum seeker to obtain corroborating evidence, but that hasn't changed. It's still possible that it will be sufficient to just give an internally consistent statement, which is also consistent with external country evidence. Very often corroborating evidence is impossible to obtain. I agree with you on that. So the asylum seeker statement would just be judged on a higher standard. Oh, and as for when it's reasonable to expect them to provide corroborating evidence, I gave a few examples of that in my presentations. For example, in their screening interview, the asylum seeker makes a claim about entering the UK on their passport and mentions that they still have their passport, so the Home Office will state that it would have been reasonable for them to provide their passport. A similar situation exists when a claimant's statement mentions that they obtained some piece of evidence from Facebook. The Home Office will not now claim that it would have been reasonable to provide the full Facebook download, the download of the full profile as evidence. So this is a slight difference in approach, but that's not connected to the standard of proof changing. It's just the Home Office trying to claim that failure to provide corroborating evidence is damaging to the credibility, which they've always tried to do. The second question was, on the basis of what I'm saying, what exactly is the difference between the first stage and the second stage of the JCK case assessment? Whether it's just needed to establish a prima facie case. So again, I apologize, I haven't gone into this more fully because of time constraints. The reasons that we have questions 1 and 2 that were mentioned on the slide in relation to the JCK case, this is purely because of the changes which were introduced to the standard of proof under Section 32 of NABA. This just changed the standard of proof applicable to asylum claims in relation to those two questions. So now the standard of proof is higher. It's the balance of probabilities when we're assessing if the asylum seeker has a convention reason and when we're assessing whether they have a subjective fear of persecution for this convention reason. And the stages still remain the same as what they were before because those questions always applied. It's just the standard of proof. And the lower standard will still apply for all other parts of the assessment. I hope that answers those questions. Thank you.
Well, that sounds like a pretty comprehensive answer, Brenda. Thank you very much. Now, there's another question from Sial Khan. I think we've got time for just this extra question, and then we'd better break off for lunch. So the question is, an Afghan national in Afghanistan was given the option to travel to the nearest country, Pakistan, for biometrics. However, the application form indicates that there are no available biometric appointments in all 4 cities in Pakistan. Yes, I gather there has been a problem recently with Pakistan. The VFS Global offices aren't open. There is no option to reschedule the appointment to another nearby country, such as Iran, nor is there any other means to contact them. We have waited for 2 weeks, but no appointment has been made. Anyone know how to contact for biometrics appointment? Well, I think if this is going to be a long-term problem, that there's no availability at the visa application centers in Pakistan, you could then make an application for an excuse from having to travel to a visa application center. I mean, if it really is the case that Afghans can't do it in Pakistan long term, and there is no way of doing it in Pakistan, then that would be a good reason for waiving the requirement for a biometric appointment. But Julian can talk about that.
I have a horrible feeling, Richard, that after the new publication of the updated guidance a few days ago, that would no longer be considered adequate grounds. The fact that it has become physically impossible for you to register your biometrics in this peculiar Orwellian system is just no longer a good enough excuse. I think the only thing that you can do at this stage is to threaten judicial review. And see if that triggers anything, because it sometimes does. So that is one option. Because there is a real problem with timing out of biometrics. You put in your application, you have 240 days to attend the appointment. What if you cannot enroll them within that time? It's an absolute nightmare. So I think you've waited 2 weeks, keep trying. I don't know whether there is anecdotal evidence from anybody that they might know locally there as to whether they all go live at 8:30 on a Monday morning or something, in which case it will be like getting Glastonbury tickets trying to get in there. Or if it becomes completely impossible, then I think you just have to threaten judicial review, or potentially see about writing to somebody extremely senior, see if you can track down who is the head of that particular VFS area. But I sympathise, because it seems that there is no good answer to that one.
Thank you very much, Julian. Well, I think we'd better knock off for lunch now. It's gone 1:15. So shall we say come back at 1:15, and we'll be resuming with, first of all, Jan Doerfel talking about business compliance, and then we'll hear from Rajiv Sharma on long residence applications, something I just mentioned very briefly at the end of my talk. And then Julian will be back after our tea break to wind up the talks with adult dependent relatives. So see you back in half an hour then, folks. Thank you. Ladies and gentlemen, we've just been joined by our next speaker, Jan Doerfel, who is a newcomer to AstenJ, but like two of our other speakers today, he is also from Goldsmiths Chambers, and we've had a long connection with that set. So welcome to you, Jan, and we hope we'll be seeing more of you during these AstenJ webinars. But I think without further ado, I'll just mention that we're going to be having, at the end of the afternoon, a panel discussion, which will range over the topics that we're going to hear about this afternoon. And perhaps if there's anything still left over from this morning, we could deal with those inquiries. But no doubt there'll be plenty of questions remaining from the three topics that we're covering this afternoon. But first of all, we'll hear from Jan Doerfel, and if there is time, Jan, before the end of your topic, maybe you could deal with any questions which have appeared in the Q&A box or the chat box, but any that there's no time to cover, we can cover hopefully in the panel discussion. So, as I said before, but didn't really mean it at the time, without further ado, over to you.
Thank you very much, Richard, and thank you very much for the invitation in general. I'm just going to see whether I can screen share the presentation. Hopefully that will work. And right. I do have to give a warning. This is incredibly dry, really. When you look at sponsorship, compliance for skilled worker visas, I mean, I think the main message to be taken home really for businesses is that this is not a space where businesses should apply their own judgment or can freely consider what is important or isn't. I think the message to be taken away is really do follow the rules and do follow the Home Office guidance. So the scope of the presentation will cover the overview of basic legislation, right to work checks, the civil penalty defenses factors to be taken into consideration, rules relating to business visits, and permitted activities for business visitors, how to challenge refusals of visit, visas, and useful links. So the legislative overview on employers' duties. The law is set out in Section 15 to 25 of the Immigration, Asylum and Nationality Act 2006, Section 24B of the Immigration Act 1971, Schedule 6 of the Immigration Act 2016, and the immigration rules. They deal with the prohibition of unlawful working. Other reference documents are Appendix D, guidance for sponsors on keeping documents, a riveting read, guidance right to work checks, an employer's guide, guidance employer's right to work checklist, and of course, the online interactive tool where employers can check if someone has the right to work in the UK. So under Section 15 of the 2006 Act, an employer may be liable to pay a civil penalty if they employ someone who does not have the right to undertake the work in question if that person commenced employment on or after the 29th of February 2008. So what do employers need to do in order not to fall foul of the prohibition? So these are the right to work checks. Most important thing is keeping evidence of sponsored workers' recruitment. It's quite simply not sufficient to say that we didn't know this person was working here unlawfully. Evidence on how workers are recruited. So employers are expected to keep detailed information either in an electronic or paper form on how workers were recruited. This means in relation to Tier 2 general migrants before the 1st of December 2020, it means showing compliance with the resident labor market test before it was abolished. It also means compliance with what has subsequently replaced that in certain categories like religious worker, the resident labor consideration. Where those tests don't apply or didn't apply at the time of recruitment, the employer still has to show that the vacancy was indeed genuine. So the employer has to keep advertising details, e.g. screenshots, copies where the job was advertised, how long for, numbers of applicants, shortlists, and other stages of the process, and at least one other item showing how the worker was selected, whether that is interview notes, a grading system, and if the job wasn't advertised, how was the worker identified as suitable for the job? So was it a speculative application received for someone who then met the requirements or a milk round? Further important information, of course, is the evidence on salary, including that it is within the category of salary that is applicable. So copies of pay slips containing relevant details, the name, national insurance number, tax code, and allowances, evidence on payment frequency, and proof that it was paid into the worker's account. Of course, of extreme importance is the employment contract, indicating start and end dates and being duly signed. Further important information is the skill level. So the job description or job spec has to be retained, copies of any relevant qualifications of the worker, including reference letters, etc., from former employers, copies of any mandatory registration where that applies, such as by the General Medical Council. As I stated before, either as hard copies or electronic versions are to be retained. How long does this information have to be kept on record? Unless stated otherwise, throughout the time of the sponsorship and the short of either 1 year thereafter or date of that the compliance officer approved the documents, or 2 years for documents involved in right-to-work checks. Of course, employers have to be aware of data protection regulations. So, what documents do you need to be specifically kept by an employer? So in terms of the evidence of the right to work checks, the employer has to check whether the sponsored worker has the right to work. And that is before they start and before the permission ends. So if these are visa dates on the passport, etc., they have to fall within that period, which means the Home Office warns that the leave to enter date and the actual start date has to work and has to be consistent. So the idea in mind is that applicants cannot basically start working before their leave to enter has been granted. How often that is actually going to be a practical problem, I can't imagine. So a copy of the passport has been taken, or if the passport doesn't show the leave to enter, then the boarding pass or travel tickets would prove when the person has entered into the UK. Then the copy of the national insurance number and a number of documents that would be acceptable issued by the HMRC. Contact details history, of course, the residential address, the personal email address, and the telephone numbers, and they must always be kept up to date. Otherwise, DBS checks, record of workers' absences, any specific documents set out in the route-specific sponsor guidance, any other documents set out in the creative worker codes of practice or sporting codes of practice. Then there's a manual document-based right to work check, which consists in 3 compulsory steps. So the employer has to obtain an original document from list A or B of acceptable documents at Annex A. And these are set out in the Home Office's employer's right to work checklist. Secondly, the employer has to check that the documents are indeed genuine, that the person presenting them is indeed the employee. So it's not a possible excuse for an employer to say, well, I thought it was that person, but in fact, it turns out it was another person, or the documents related to another person. It has to be the rightful holder, and he or she has to be allowed to do the type of work. In terms of step 3, a clear copy of each document has to be retained in a format which cannot be manually altered. So that could be a secure hard copy, in which case, if there are copy documents, it has to be noted when those were copied and when the date of the right to work check was taken. Now the thrilling lists of the documents. So list A, a current passport, endorsed with permission to stay in the UK and undertake the type of work in question. Document issued by Guernsey, Jersey, or the IOM as valid by the Home Office Employer Checking Service, showing a leave to enter, leave to remain grant respectively. A current passport endorsed to show the holder is exempt from immigration control, but has the UK right of abode or unlimited stay. And a current immigration status document with a photo issued by the Home Office with valid endorsement indicating that the person can stay or work, and a birth or adoption certificate issued in the UK. And the certificate for registration, naturalization as a British citizen. List B is divided up in 2 groups. One is group 1, a current passport endorsed with permission to stay in the UK and undertake the type of work in question. Again, document issued by Jersey, Guernsey, or the IOM. And a current immigration status document issued by the Home Office, again, with a valid endorsement indicating that the employee can stay and work. Group 2 would be a Home Office issued document showing settled status under the EU settlement scheme, certificate of application, proving that an application has been made. And again, documents issued by Jersey, Guernsey, and the IOM. An asylum registration card, a Home Office issued positive verification notice. Again, copies have to be retained of passports, and here it's set out which passport pages are required. Again, expiry date, of course, the nationality, date of birth, signature, immigration permission, expiry date, biometric details, and any information indicating that the holder has an entitlement to enter or remain in the UK and can undertake the work in question. All other documents, the full copy has to be taken, including both sides of an immigration status document and an ARC card. Again, the information has to be kept securely for the duration of the worker's employer and for 2 years afterwards. Checking document validity. So as stated before, it's important to check the documents before the start of the employment and in the holder's presence. Now, this can be done in the physical presence of the prospective employee or via a live link. but the employer has to be in physical possession of the original documents. What are acceptable documents? So from list A and B of the guidance, and we've gone through this. So the list A is the strongest range of documents. So that is for people with continuous right to work in the UK, including British and Irish citizens, which will establish a continuous statutory excuse for the duration of the employment. So no follow-up checks are necessary. List B establishes a time-limited statutory excuse and contains the acceptable documents showing that the person has a temporary right to work in the UK. Now, the issue of false documents. The employer is responsible for checking. So if given a false document, the employer is only liable for civil penalty if it is reasonably apparent it is false. So the employer cannot be expected to be an expert on checking the veracity of documents. The test is whether a person who is untrained in the identification of false documents, examining it carefully, but without the use of technological aids, could reasonably be expected to realize that the document in question is not genuine. It's no statutory excuse, unsurprisingly, if it's apparent, reasonably apparent, that the person presenting the document is not the person referred to therein. If the employer knows that the individual is not permitted to undertake the particular work in question, for example, if they've been given the right to work waiting for an asylum decision, and if you know that the documents are false or do not rightfully belong to the holder. Now, the civil penalties are set out in Section 15 of the Immigration, Asylum and Nationality Act 2006. What is the process? So, first, the employer is found employing a person without permission. Then the Home Office can refer the employer by serving a civil penalty referral notice. The referral notice will inform the employer about the process and the date of breach. And then the Home Office can contact the employer with an information request, requesting, for example, any evidence that the employer has a statutory excuse. If the employer replies within 10 days, this is considered as active cooperation and can lead to a possible reduction in the penalty. Well, I will come to that. Then there's the decision. If the employer is held liable, the Home Office will issue a civil penalty notice, and that will set out the reasons, the amount of the penalty, and the date by which payment is due. If not, then a no action notice is issued. If payment is made within 21 days, there's a 30% reduction of the fine. And the starting point is £45,000 per worker for the first breach within the last 3 years, £60,000 per worker for a repeat breach within 3 years. But as referred to just a minute ago, mitigation factors might reduce the penalty. So, first one is if the employer has reported the illegal worker to the Home Office and received a unique reference number, that can lead to a reduction of £5,000. Active cooperation, again, can lead to a reduction of £5,000. Active cooperation means not only replying, but within a certain amount of time, but providing the Home Office with access to premises and documents, full access. Responding promptly, honestly, and accurately to questions, making themselves available to the Home Office during visits, and fully and promptly disclosing any assistive evidence to the Home Office. Then, if the employer has proven that mitigating factors 1 and 2 apply, then if the employer has effective right to work checking practices, then another reduction would apply of £5,000. So in total, a reduction of £15,000 can apply. So it's a code of practice on preventing illegal working. So defense to civil penalty. So again, in order to establish a statutory excuse against a civil penalty when employees found to be working illegally, employers must do one of the following. So carry out a manual right to work check. Well, I've set that out in detail before. Carry out a right to work check using identity document validation technology via the services of an identity service provider for British and Irish citizens only. Conduct a Home Office online right to work check. Contact the employer checking service when an individual has an outstanding application, administrative review or appeal, or if the immigration status requires verification by the Home Office. How can civil penalties be challenged? So an employer can seek to object within 28 days on the ground that he's not liable to the imposition of a penalty. He's excused payment by virtue of Section 15(3), i.e. that he has carried out right to work checks. That the amount of the penalty is too high, i.e. that there are mitigating factors. The Home Office will then issue an objection outcome notice and inform the employer what the decision is. So the outcome can be either to cancel, reduce, or increase the penalty, or take no action at all. So if the employer is unhappy with the outcome of the notice, they can appeal to the county court within 28 days on the same grounds. The court may allow the appeal and cancel the penalty, allow the appeal and reduce the penalty, or dismiss the appeal. Again, the court can take into account any matters in the code of practice on preventing illegal working, the right to work scheme for employers, but also any other matter that the court considers relevant. Of course, there is a costs risk if the employer loses the county court case. And now I'm going over to a different topic. Again, it will cover what businesses have to supply, but the focus is more on what business visitors are now allowed to do since recent changes. So business visits, they're set out in the immigration rules, as everyone probably knows, in Appendix 5, visitor. Of course, all applicants, including business visitors, need to meet the basic requirements for a standard visit visa, including suitability, eligibility, the genuine visitor requirement. Of course, this is the intention to return, sufficient financial resources to pay for the visit. So visitors cannot work in the UK unless this is expressly allowed under Appendix Visitor Permitted Activities. What are the permitted activities for business visitors? To attend meetings, conferences, seminars, and interviews, to give one-off or a short series of talks, provided these are not paid, except for permitted paid engagements, negotiate and sign deals and contracts, attend trade fairs, providing there's no direct selling involved, carry out site visits and inspections, gather information for employment overseas, be briefed on requirements of a UK-based customer, provided any work for them is done outside the UK, undertake activities relating to their employment overseas, remotely from within the UK, providing this is not the primary purpose of their visit. Overseas-based company employees may advise and consult, troubleshoot, provide training, and share skills and knowledge on a specific internal project with UK employees of the same corporate group and directly with clients where this is incidental to their employment and required for the delivery of a project by the UK branch. Internal auditors may carry out regulatory or financial audits at a UK branch of the same group of companies as the visitors' employers overseas. So this is effectively intra-company activities. Deliver training or share knowledge on internal projects with UK employees of the same company the visitor works for overseas. Overseas company employees may also install, dismantle, repair, service or advise on machinery, equipment, computer software or hardware, or train UK-based workers to provide these services if the visitor's overseas company has a contract with the UK company or organization. Get work-related training if a visitor is employed overseas and the training is not available in his or her home country, and oversee the delivery of goods and services provided by a UK company to the visitor's overseas company or organization. What are now the permitted paid engagements? Applicants can visit the UK for certain paid engagements or events if they have a written invitation from a UK-based organization or client for pre-arranged event or other permitted engagement, can show that they're experts in their profession, are 18 or over, and the engagement needs to be completed within the 30 days of the visit. So the visit visa is still likely to be granted for a period of 6 months or so, but all these engagements have to take place in the first month. Engagement must be relevant to expertise, qualifications, and employment in the home country of the applicant. So which professions does that affect? So professional artists, entertainers, or musicians, which can be anyone working in the performing or creative arts, such as poets, makeup artists, set designers, stylists, fashion models, and photographers. They can be paid to do any activity relating to their profession, including performing, presenting, launching their work to other professionals or the public, giving lectures, joining judging or debate panels, and taking part in professional conferences. What they need is an invitation from a UK-based creative organization, such as a gallery, university, arts faculty, school or events venue, agent or agency, broadcaster, and they need to show that they are an established artist, entertainer, or musician through published works, publicity material, media coverage, and reviews, or awards received. Professional and established sports people. They can be paid to do any activity that relates directly to their sporting profession, e.g. take part in a sporting event. Again, they need an invitation from a UK-based sports organization that organizes or hosts sporting events or matches, an agent or an agency, and a broadcaster. They need to show expertise and employment, proof of recent performances, awards, media coverage, there's some duplication, and qualified lawyers can be paid by a client to represent them in the UK at a court tribunal hearing, at an arbitration or other form of legal dispute resolution, and for the preparation of the hearing. The requirements: an invitation from the client, confirmation of right of audience, qualification, i.e. a practicing certificate or a certificate of good standing. Lecturers can be paid to give a lecture or series of lectures about their area of expertise, but cannot take a full-time, part-time teaching post. What are the requirements? An invitation from a UK-based higher education institution, research organization, arts organization, e.g. a museum, theatre, art gallery, arts festival, or other arts venue. Show expertise and employment, an employer's letter confirming their expertise or employment, example of published work, and an applicant can visit for a permitted paid event if semi-retired and earning an income from giving regular lectures, but not if fully retired. Academic assessors and examiners can be paid to examine and assess students and take part in selection panels. Again, they also need an invitation from a UK higher education institution or UK-based research or arts organization. And again, have to show relevance of expertise, that they're highly qualified through, for example, a letter from an employer, examples of published work, and evidence of lectures already given. They can visit for a permitted paid event or engagement, again, if semi-retired but not fully retired. Conference speakers, they need to show an invitation to speak from the organizer of a conference or seminar. and show that the topic is relevant to their area of expertise and profession in their home country. Air pilot examiners can be paid to examine UK-based air pilots so they meet the national aviation regulatory requirements of the applicant's country. Requirements: invitation from a UK-based approved training organization such as the Civil Aviation Authority or regulated by the UK Civil Aviation Authority, must be able to show full-time employment overseas with the National Aviation Authority of their country of residence. Additional eligibility requirements apply for academics seeking to come to the UK for more than 6 months and for visitors coming to the UK for work-related training. So what activities are allowed as part of an overseas job role, or for who? An applicant can do certain additional activities in the UK as a standard visitor if employed overseas as an archaeologist, an artist, entertainer or musician, a bodyguard or a camera operator, driver, an internal auditor, a journalist or correspondent, a lawyer or expert witness, a market researcher or analyst, personal assistant, a pilot or cabin crew member coming to work in the UK under a wet lease agreement approved by the Civil Aviation Authority, a professor from an overseas academic institution, a religious worker, a scientist or researcher, a seafarer, sports person or sports official, a tour group courier, a translator or interpreter, a member of a film crew including actors, producers, directors or technicians, a member of the production team supporting an artist, entertainer or musician. And these are set out in detail in Appendix Visitor PA paragraphs 9 to 15 on the permitted activities. Again, a member of the technical staff supporting an artist. So it also covers the sort of entourage of the other professions set out. I've only decided to give one example. The rest can be looked up. Here, lawyers or expert witnesses. An expert witness may visit the UK to give evidence in a UK court. Other witnesses may only attend a court hearing if summoned in person. An overseas lawyer may provide legal services, including advice, appearing in arbitrations, acting as an arbitrator or mediator, acting as an expert witness, and appearing in court in jurisdictions which allow short-term call or where qualified in that jurisdiction, and taking part in conferences and teaching, as well as providing advocacy for court or tribunal hearing and litigation, as well as transactional legal services, including drafting contracts. Now, as you probably all know, how can you challenge refusals? Well, there is no right of appeal against visit visas. So the judicial review route is the way to go. That requires the sending of a pre-action protocol letter, setting out all the possible grounds of challenge. The Home Office is then given 14 days to reply. Often the Home Office will consider an offer to reconsider, especially if they fail to either properly read or take into account evidence submitted with the application. So often it might not be necessary to go and lodge full judicial review proceedings. My presentation also contains some useful links, and I would like to thank the organizers of the conference for inviting me and for organizing such an interesting conference.
Well, Jan, thank you very much. That was a most interesting talk, and especially, as you said yourself, given the dryness of the subject, you've actually made it very comprehensible and easily understandable. So thank you very much for that. And I'm not sure if we've got any questions in the chat box for you, but if not, hopefully you'll be able to stay for the panel discussion, and there may well be something on your topic during that.
Thank you. I will.
See you later then, Jan. Thank you very much.
Thank you very much.
Well, now, ladies and gentlemen, we're going to be following on from Jan's talk with a talk from Rajiv Sharma, who is waiting in the wings. And he's going to talk about long residence applications. There was a great flurry of interest in that aspect of immigration law earlier this year. And Rajiv will be bringing us up to date on the latest developments. Now, I see that we're actually well within our time scale. We've got until 3 o'clock when we have a tea break, though we may finish a bit before that, but we've got plenty of time, and hopefully Rajiv will be able to answer questions in the Q&A box, which are put in there during his talk. So I think without any further ado, let me welcome Rajiv, who is from the 36 group and is paying his first visit to an AstenJ webinar. So Rajiv, welcome, and hope you have a productive and enjoyable time with AstenJ this afternoon, and that you aren't bombarded with too many questions towards the end of your topic that you have to answer. But anyway, I'd better let you get on with it. As I say, we'll be knocking off for afternoon tea at 3 o'clock or a bit before if we get finished with Rajiv's talk and Q&A sooner than that. So over to you, Rajiv.
Thank you. Good afternoon, everybody. If you just bear with me one moment, I'm going to see if I can replace the slides that are on the screen with the slides for my seminar, which you'll find in your attendance pack there.
Oh, I think Jan has to be asked if he can help to take his slides off the screen and make way for Rajiv's. So please bear with us while this is being done.
According to what I'm seeing, I can see that my slides are on the screen. Would anyone be able to confirm what they're able to see?
Oh, I can
Please?
only see Jan's slides on my screen at the moment. Ah, here are yours now, Rajiv.
Excellent.
That's it.
Great. So good afternoon, everyone. I've just joined and I heard the end of Jan's talk. It sounded very interesting. I hope everybody's had an interesting talk so far. I've missed the 2 sessions earlier this morning, so hoping to catch up on those with the slides that have been provided in the pack. And I hope everybody has sufficient energy to bear with me for this trawl through long residence. If you would just excuse me, I am looking off to the side. I've got another screen with my own notes on them, so I will be looking through that whilst also showing you the slides that you're seeing on your screen. So as was referred to there, I'm going to be going through long residence. This set of materials is up to date as of the 22nd of October, which is today, and it is essentially going to be bringing you up to date with what the position is in long residence. This is a practical guide to the making of long residence applications. We'll see at the end of my talk that the talk of the theme of this seminar shares a name with a book that I've written that I wrote a couple of years ago now about long residence, but I'll explain why we needed to be brought up to date. As was referred to earlier, this is my first time speaking with the organization, so there may be many of you who don't know me, so let me introduce myself. First of all, my name is Rajiv Sharma. I'm a public law barrister at the 36 Group Chambers in London. I was called to the bar in 2008. I've been practicing in public law since then. I mainly do immigration work. I'd say roughly 80% of my work is immigration, both through the statutory scheme and also judicial review work. I also do some housing, local authority, and general civil, but I like to say it all falls within the public law realm. So anything that really involves public bodies in those sort of practice areas. So that's what I do. Now, what we're going to be doing today is going through the relatively new rules in relation to long residence applications. What we're looking at specifically is continuous lawful residence, and we'll look at those two elements in a moment. But when we say long residence, that's what we mean. We mean the continuous lawful residence, not appendix private life insofar as it concerns 20 years residence, which is of course also long residence, but not continuous lawful residence. So I've said in this slide that we'll be looking at the relatively new rules. These rules were published on the 14th of March 2024. They came into force on the 11th of April 2024. We'll look in a moment at the transitional arrangements, which will be on the next slide. But insofar as appendix long residence as a route for application is concerned, applications from the 11th of April 2024. They were brought about by the statement of changes laid before the House of Commons in HC 590 of 2024. Now, HC 590 was, most of you will remember it, probably not fondly. It's a mammoth statement of changes, 292 pages. It includes, among other things, the thresholds being increased for the minimum income for skilled workers. It also includes the graduated increase of income under the partner route. So those two elements were within that statement of changes. And slightly uniquely, although it has been something that's been more common recently, the explanatory memorandum to the statement of changes is a separate document. And it's a document in this case that runs to 17 pages. And the reason it gives for this particular change, so bringing about appendix long residence, is basically for greater consistency across immigration routes, to make standard requirements within appendix continuous residence, which is something we'll look at as well, to bring it in line with appendix English language and appendix knowledge of life in the UK, and apply those to the long residence route in a more structured way, in a way that wasn't previously as easy to follow. It also includes a policy change whereby applicants must have had their current permission for at least a year or have been exempt from immigration control within those 12 months prior to the application in order to qualify for settlement. So it brings that additional requirement in. A lot of this was essentially last minute politicking by the previous government in order to try and do something about what they saw as the problem of mass immigration. And so a lot of what was brought in these 292 pages was an attempt to appease those from whom they wished to obtain votes in relation to what they saw as a problem with the number of immigrants entering the United Kingdom. So these are the new rules that take effect from the 11th of April 2024, but as I foreshadowed earlier, there are transitional provisions. So what those transitional provisions tell us is that the paragraphs that bring into effect appendix long residence take effect from the 11th of April 2024. What that means is that any application being made today, i.e. after the 11th of April 2024, will be made under the new rules. So we'll focus most of our attention today on those, and then depending on how much time we have left towards the end, we will look back at any applications affected by these transitional provisions, which say that any applications for entry clearance, permission to enter, permission to stay that had been made before the 11th of April, so applications made before the date on which these rules come into force, those applications will be decided under the rules in force prior to the 11th of April, so those in force on the 10th of April 2024. So for those of you who particularly were interested in what the new rules require, don't worry, that's the first thing we're going to look at in the first half of my talk. For those of you who wanted to be brought up to date in relation to the previous provisions, again, don't worry, that's something we'll look at when we finish looking at the rules as they take effect from the 11th of April of this year. So what is it that form the basic requirements of the new appendix long residence? Much of this will not come as a surprise. The first is a qualifying period of 10 years with lawful residence, which is defined within the provisions. And we're looking at long residence 3.1 and long residence 3.2 in order to be able to meet these qualifications. So that's a simple calculation about the period of residence. What also is required is that that residence be continuous. And for some reason, the definition of continuous falls out with these rules in another appendix. But that requirement itself comes from LR 4.1. So we've got essentially two strands of requirements. One is residence within the qualifying period of 10 years, and that residence be lawful. And secondly, that residence be continuous, i.e. not broken. So those are the requirements under the new rules. At this stage, nothing too different to 276B as was the previous set of requirements. Now, what is slightly different is the grant of leave, or at least the initial grant of leave. Under one of the routes in Appendix Long Residence, the grant of leave to remain, which they've called permission to stay, but those traditionalists among us will know it as leave to remain, is a grant of leave or permission for 24 months. What this tells us is that there is a separate route under this rule for settlement. Again, those of us with enough experience on 276B will know that this was actually part of 276, the long residence rules previously in any event, for individuals, for example, who hadn't satisfied the English language requirement. There was a provision under which 24 months leave would be granted, essentially enough time to be able to bring themselves within the settlement rules. In this case, as was set out in the explanatory memorandum, there is a requirement to have been settled or free from immigration status for at least 12 months. So it brings this in line with that particular requirement, or it enforces that requirement. So that's the grant of leave under the permission to stay route. There are some slightly different requirements in relation to the settlement route. So first of all, the same requirements that apply to permission to stay in terms of length of residence and continuity of residence apply. Those are with reference to LR 11.1 and LR 12.1. Plus, there are two additional requirements. And again, something that won't be too dissimilar to previous requirements under 276B is the English language requirement, LR 13.1, and knowledge of life in the UK requirement, LR 14.1. So essentially, what is required in the settlement route are these additional two requirements of English language and knowledge of life in the UK. There are, of course, requirements that apply that are more standardized. So sorts of requirements that you'd find in other types of applications. So these concern things like the validity of the application, so that the correct application form is used, that the applicable fee is paid. This relates to both the application form and any IHS fee that is payable. That any request to enroll biometrics is complied with, and any request to provide a passport is also satisfied. So those are the sorts of general validity types of requirements that one would expect in such applications. And then we also have the suitability requirements. So Part 9 with reference to the general grounds for refusal, and the sorts of Part 39 or Paragraph 39E type of requirements, i.e. that an individual have leave to remain unless they satisfy Paragraph 39E. Part 9 is possibly where things get interesting on a litigation point of view. because here we will see possibly issues with reference to immigration history in the past. So rather than an individual being without leave at the time of the application, we may also see issues with non-conducive types of refusals. So individuals who, for example, fell foul of 3225 at some point in the past may find themselves falling foul of the requirements here. Individuals who, for example, taken part in one of those sham operations that the Home Office had focused on ETS, HMRC type of frauds is what I'm thinking of there. They may find themselves falling foul of the suitability requirements. So although we have rules that are more codified and more similar to the points-based in terms of it being almost like a flowchart, that discretion for the Secretary of State and that ability to apply the general grounds for refusal, or what are now called grounds for refusal under Part 9, continue to have application and continue to bite in applications of this kind. So that's a brief overview of what is required under Appendix Long Residence. We then move on to the other referred provision, which is Appendix Continuous Residence. Now, what I'm hoping to be able to avoid here is simply reading out what Appendix Continuous Residence sets out. But I have gone through the provisions and set out essentially a summary of what the relevant requirements are in the slides. So Appendix Continuous Residence is referred to as CR, Continuous Residence, or Appendix CR. And the first thing that we find is importing the requirement to meet the rule in order for continuous residence, in order for the continuous residence requirement to be met. This is basically a complicated way of saying that in order to meet the definition of having had continuous residence, an applicant has to satisfy what is set out in Appendix Continuous Residence. So what the rule actually says is the continuous residence requirement is met if the applicant has spent the qualifying unbroken continuous residence period required by their route lawfully in the UK. Slightly circular because it again requires the lawful residence point, which is already made within long residence, and the continuous residence element is again part of long residence, but it does refer out to Appendix Continuous Residence. And this appendix, at least as we'll see in a slide further down, does attempt at least to try and identify what is meant by what kinds of factors are able to break up continuous residence. You'll have heard from the introduction to my talk that this was something that exercised particularly the courts at the start of this year and indeed last year in relation to things like book-ended leave, open-ended leave, and we'll look at that later on. Things like whether or not the disregard, i.e. periods of overstaying that could be disregarded, were simply disregarded as overstaying but counted towards lawful residence. So those types of complications that arose in the case law. The hope is that continuous residence through these appendices will be more easy to understand. Okay, so that's continuous residence 1.1. Let's look at CR2. CR2 effectively looks at the permitted absences from the United Kingdom. So it looks at the period of absence that's allowed. It looks at what exceptions there are to periods of residence that would ordinarily be disqualifying, i.e. would mean that an individual isn't able to apply anymore, and does apply slightly different rules depending on the nature of the application that is being made. And the difficulty with that is, one, it's unwieldy. The actual provision is very long. And two, because it sets different rules for different types of applications, it does become fairly complicated to be able to advise on a general basis of what the rules say without essentially reading through or reading out all of the rules. But the underlying point is that an applicant must not have been outside of the UK for more than 180 days is in any 12-month period, unless the exceptions apply. For any absence from the UK before the 11th of January 2018, the applicant must not have been outside of the UK for more than 180 days during any consecutive 12-month period. And that period ends on the same day as the day of their current application. So it's taken in 12-month chunks. Again, unless the exceptions apply. If an application is made under the appendix long residence, the applicant must not have, and there are two requirements here, spent more than 548 days outside of the UK during the qualifying period, if that 548-day total was reached before the coming into force of these rules, and must not have been outside the UK for more than 184 days at any one time during the qualifying period, where that absence started before the 11th of April 2024. So it's essentially providing notice that from the 11th of April 2024, the rules have changed, but it is allowing those that had residence of absences, sorry, 548 days before those rules, or at least where they started before those rules came into force, is providing a route for those individuals. The provision also tells us how to calculate a period of absence. This is under 2.3, so CR 2.3. A period of absence will not count towards the total period of absence if it was for one of the reasons set out. And those reasons are that the applicant was assisting with a national or international humanitarian or environmental crisis overseas. If that individual was on a sponsored route, their sponsor had to have agreed for absence for that purpose. So the first exception is for individuals who are assisting on national or international humanitarian or environmental crises overseas. And if that individual were sponsored, then their sponsor had to agree to the absence for that specific purpose. Another exception is if the individual had to was forced, if the absence was forced through travel disruption due to a natural disaster, a military conflict, or a pandemic. So again, you could see the reason why in April 2024 such exceptions would be considered. So exceptions essentially on the basis of matters outside of an applicant's control. Whether there are compelling, compassionate personal circumstances such as the life-threatening illness of the applicant or life-threatening illness or death of a close family member. Now, this is interesting because this is a slight change to what the previous rules said. It does bring into the rules consideration of the state of health of family members. Because in my opinion, even when taken with the previous guidance in relation to absences, the consideration that an individual may be abroad for reasons other than for family reasons other than their own illness were conspicuous in their absence. There's something that is taken into consideration in relation to these codified exceptions. Although I will observe that it does say life-threatening, so it does set the benchmark fairly high. And then the next exception is where an individual is absent because of research activity they're undertaking as a skilled worker, again, approved by their sponsor, and it sets out a number of occupation codes to which this exception applies. So there are multiple exceptions that apply to skilled workers as long as their absence was approved by their sponsor and they fall within one of the approved codes. There's a similar provision for research activity undertaken by a person on a global talent route. Again, as long as they were endorsed by the Royal Society, the British Academy, the Royal Academy of Engineering, or UKRI. I think that's the majority of mainstream bodies that can endorse an individual on the global talent route. Of course, there are others, but it caters for at least 4 of those in one of the exceptions. There's another exception for individuals on the global talent route, which is research undertaken by a person who's on that route, who qualified on the basis of a prize that is listed at table 6 of Appendix Global Talent, so the prestigious prizes route under the global talent. So if research activity requires an individual's absence on that basis, that absence will not count towards the period. If an applicant is attempting to settle under Appendix Settlement Family Life, any absences for work, study, or to support family overseas will not count towards, so long as the family have throughout maintained family life in the UK and that the UK has remained part of their place of permanent residence. So again, taking into account family circumstances, sometimes it does mean that family members will need to be absent as long as they've maintained their family life in the UK throughout that period and the UK has remained part of their place of permanent residence. That absence will not count towards the overall total period. And finally, if an applicant's partner is absent from the UK on Crown service, that period of absence will not count towards the overall period. So that's 2.3 in relation to some of the exceptions with reference to absences from the UK. There are some absences that apply for long residence applications where an individual has been resident in the Channel Islands or the Isle of Man, unless the individual is applying under Appendix Long Residence, that residence, or any time spent in the Channel Islands or Isle of Man, will be treated under this appendix as time spent in the UK, provided that the applicant's most recent grant of permission was in the UK. It's a strange exception, but essentially, if you're on a route other than Appendix Long Residence, then that period, Channel Islands or Isle of Man residence, does count towards time spent in the UK, whereas under the long residence route it won't. And of course, it's also subject to that the most recent period of grant should have been for the UK. So that's 2.4. 2.5 provides for absence from the UK before the 20th of June 2022 will not be counted when calculating continuous residence for settlement applications under Appendix Settlement Family Life, if the applicant was subsequently granted permission as a partner, etc., following those absences. So if there's been a grant of leave under Appendix FM in knowledge of previous absences, then those won't count as absences for the period, for an application under continuous residence where that period was before the 20th of June 2022. And finally, any absence from the UK which began before the 8th of October 2024 will not be counted when calculating continuous residence period settlement applications under Appendix HM Armed Forces. So that's CR 2.6. All very technical, all very fact sensitive. So the basis of this will be an individual advising applicants about whether or not certain absences disqualify them. We'll need to look at the exceptions set out. But ultimately, we know that it's as set out in continuous residence, and hopefully gives us one place to look rather than having to look through multiple different avenues. That then takes us on to CR3, which is with reference to dependents and how absences of the person upon whom they are dependent will affect their own application. So to try and clarify that slightly difficult wording, if person A is applying and is dependent on person B, the question here is how person B's absences would affect person A's application. And it basically sets out that the period of absence will not count towards the 180-day absence where certain requirements are met. It sets out the requirements in terms of the different points-based versions of the grants of leave, etc. So it tells us essentially what the effect of person B's absence will be in relation to an application for person A. CR4 then tells us how continuity is broken. Now, as you'd imagine, this is one of the more wordy elements of continuous residence, appendix continuous residence. I've summarized it on this slide in the sense of it including the types of things that you'd expect it to include. So continuity will be broken through convictions and imprisonment, which is important because it requires both. Broken through the making of a deportation order, broken through the issuing of removal directions. Now you'll remember some of you will remember under previous legislative schemes, the making of a Section 10 decision, as I found out multiple times from the Court of Appeal to my detriment, the making of a Section 10 decision invalidates or cancels any leave that has previously been granted. It also stops the clock for the purpose of continuous residence, not a Section 10, but a removal direction in this case, because the Section 10 scheme has been dispensed with. Removal directions being set will break continuity, and of course absences that are not permitted from the immigration rules will also have the effect of breaking continuity. Now, if necessary, we can go through those rules in a bit more detail, but as I say, one of the important things to take into account here is that 4.1a makes specific reference to an applicant being convicted of an offence and sentenced to a period of imprisonment, or being directed to be detained in an institution, so being institutionalized, unless the applicant is applying for settlement under Appendix Settlement Family Life or Appendix Private Life, in which case a different provision will apply. And that different provision says where a person applying for settlement under Appendix Settlement Family Life or Appendix Private Life has been convicted of an offence and sentenced to imprisonment in the UK for 12 months or less, or directed to be detained for 12 months or less, that period of imprisonment will not break the applicant's continuous residence. So under those two routes, if it's imprisonment or institutionalized detention for less than 12 months, or a period fewer than 12 full months, that period will not act to break continuity of residence. The provision also goes on to define essentially what is meant by an individual having permission to be in the United Kingdom. So it talks about the effect of paragraph 39E, i.e. The provision in which an individual can make an application, the period in which an individual can make an application despite them not having residence at the time, where that period of overstaying will essentially be overlooked for the purpose of an application being made. It makes an exception for appendix long residence. So it says an applicant who had permission when they left the United Kingdom, who applied for entry clearance before that permission expired, or within 14 days of that permission expiring, and the application for entry clearance being successful, will not count towards breaking of continuity, except where the application is made under appendix long residence. So essentially that says an individual who leaves the UK with no route to come back to the UK, or at least at that time with no route to come back to the UK lawfully, doesn't have an exception to the breaking of continuous residence in those circumstances. And as I say in the slide, deportation orders, the issuing of removal directions, and unauthorized absence from the UK and immigration breaches all have the effect of breaking the continuity of residence. And this is something that, again, as we referred to, did trouble the courts, particularly in relation to what we refer to as bookended and open-ended overstaying. So periods of time when an individual had no permission to be in the UK, what the effect of that was. Appendix continuous residence attempts to tell us what effect that has on the totality of the period and the calculation that is to be carried out. CR5 defines what is meant by an individual being lawfully present in the United Kingdom for the purposes of CR 1.1. It tells us that the following periods will not count towards what is considered to be lawful presence in the United Kingdom. Specifically makes reference to period of imprisonment or detention under CR 4.1 or 4.4. Those, depending on the route for application, means any period of residence if it's a particular type of application, or if it's under appendix family settlement, then it's for 12 months or less. During any period, the applicant is subject to a deportation order, exclusion order, or exclusion direction. So that period obviously will not count towards lawfulness of residence. Any period that an applicant is subject to removal directions under Section 10 of the 1999 Act, and this provision doesn't apply to appendix long residence. It applies to other provisions, but not long residence. And during any period where an applicant required permission and did not have it, unless it is from the 1st to the 31st of August 2020, and immediately prior to that period, the applicant had residence, in which case they would be treated as having been lawfully present during the month of August 2020. So that's the definition of lawfulness. And then finally, insofar as appendix continuous residence is concerned, CR6 tells us how the period of continuous residence will be calculated. It tells us that it will be by counting back from whichever of the following dates is the most beneficial to the applicant. That is A, the date of the application, B, any date up to 28 days after the date of the application, C, the date of the decision, or D, for a person applying for settlement from the UK on the ancestry route, the date of their last grant of permission. So those are the specific periods that are set out in appendix continuous residence. That's how we're told to calculate the period of lawful residence in the UK. And that essentially brings us to the end of the update, or being brought up to date with what the current version of the immigration rules says. That means then the next thing for us to do is to take a step back and to try and look at what the previous rules required and what it was that the courts were getting so exercised about. Now, what you'll see is I've provided 2 slides worth of citations, references to case law. And my voice is already getting slightly hoarse, so I don't intend on going through all of these in lots of detail. One, because these don't really apply to any new applications being made. 2, they will apply to appeals, etc., but will be very fact sensitive, and their application will depend on what is happening in the cases. And 3, some of them actually are no longer good law. Indeed, one of the cases that we've looked at is many of the cases that we've looked at have been reconsidered by the courts, and we have more information than what the court had at the time when they made the decision. So they've been either overturned or clarified, or some form of watering down of any principles has been conducted. So I don't intend to go through all of these in detail. You've got all of the citations in the slides in your packs, but what I will do is provide my very brief summaries of some of the more important cases, and that will hopefully take us essentially to the end of the session. So I've taken things slightly out of order in terms of timing and in terms of the relevant cases and the sort of precedent factor of the cases. So I would ordinarily have started with the upper tribunal cases and gone on to the Court of Appeal, but I think it makes sense to begin with Hock, because I think Hock is essentially where a lot of the more recent, the more modern case law comes from, where a lot of the decisions flow from. So Hock was about legal interpretation. So it interpreted paragraph 276B, and what it did, in the words of the Court of Appeal, was conduct a little bit of violence on the wording of the immigration rules in order to be able to interpret it properly. And essentially what it did was to find that one part of the immigration rules had to be disjointed or removed from the part under which it appeared and put into a separate section. And this is with references to Roman 1 and Roman 5 or V. It essentially said that subparagraph 1A was expressed in the past tense and therefore related to 10 years continuous residence, whereas Roman 5 was expressed in the present tense and referred to an applicant's current status at the moment, at the time of the decision. Having said that, the last sentence of paragraph 5 referred to overstaying between periods of leave and therefore couldn't belong to Roman 5. It had to belong to a different part because Roman 5 looks at the current situation. So it was found that that was a drafting error, and essentially that particular part of Roman 5 had to be removed and put within subparagraph Roman 1A. And so that was the violence to the rules that had to be conducted, because in order to properly interpret the rules, that part of 5, which referred to the last sentence, which referred to overstaying between periods of leave, couldn't be something that dealt with the present. It had to be something that dealt with the past, and therefore had to be part of that other earlier sub-provision. What was interesting is that in this particular case, the Court of Appeal suggested, not for the first time, and not for the last time either, that paragraph 276B, all long residence required wholesale change. And any in-depth reading of the Court of Appeal judgments thereafter will illustrate that multiple promises had been made by the Secretary of State at the time that the rules would be changed. And as we know, those rules were only changed some 4 years later, in March 2024. But those were that's what was found in the case of Hock. Wasim, I'll deal with very quickly, essentially found that there was a legitimate reason to deal with open-ended and book-ended leave and grants of leave, or periods without leave differently. There was a good reason when following the litigation and statutory history in terms of the way that paragraph 276B had been drafted and amended. There was a good reason to treat the two different types of leave differently. Just on that, what we mean by open-ended periods without leave is where an individual fell into a period where they had no leave to remain, and that period has not ended. So that's open-ended. Whereas book-ended periods without leave is different. An individual falls into a period without leave to remain. They then subsequently get granted a period of leave to remain. We can't see my hands. Subsequently get granted a period of leave to remain afterwards. So lawful residence stops or leave to remain ends. There's a period with no leave, and then lawful residence begins again. Bookended refers to that period in the middle, because it's bookended by 2 grants of leave to remain or 2 periods of leave to remain. And Wasim said that there's a good reason to treat the two things differently. Moving on to deal with the case of Mungu, not particularly interesting for any real reason other than it's not clear why the Secretary of State sought to challenge it to that point, but it deals with the interpretation of paragraph 276B, but in reality, all it tells us is that grants of leave as a visitor count toward counted towards lawful residence at that particular point. So it was just how paragraph 276b was to be interpreted with reference to grants of leave as a visitor. I've skipped out ASIF, which I'll come to now. ASIF was talking about a proper construction of paragraph 276b, and essentially found that any period of overstaying that is to be disregarded is to be treated as lawful residence for the purpose of paragraph 276b1. So any periods of overstaying disregarded under 276b were to be treated as lawful residence. Now, that needs to be caveated by what is going to be said in the next slide. So that is what ASIF said. That's what the upper tribunal said in that case, but that has to be caveated with what's said later. Akinola, actually, I find quite an interesting decision. It deals with a number of things. It deals with the circumstances or the effect of certain intricacies within immigration litigation and what effect that has on leave to remain and the continuity of leave to remain. It dealt with what happens in the circumstances where an application for an extension of leave, extension of the deadline to bring an appeal is made. Now, there were two different circumstances. The circumstances in which an appeal or an application that is made is invalid ab initio from the outset, or situations in which an application can be validated later on or is missing something that later on is requested. Essentially, when in relation to grants of an extension of time to appeal, when an extension of time was granted, it renders the notice of appeal effective from the date when it was filed, so that the appeal proceedings were instituted at the date when the application was filed, rather than the date from when the decision to extend time was made. So essentially, it validates or revalidates that period from the initial bringing of the application to appeal, even if it was made out of time, once the extension is granted. So all of that period would count for the purposes of Section 3C of the 1971 Act. It also deals with, and this was the part that I found more interesting, was the effect of judicial review or other challenges to decisions, which leads to a withdrawal of a decision. And it effectively distinguishes between the withdrawal of a decision for any perceived defect or any actual defect and a decision being quashed on challenge. And it showed us that there is a difference between the two. And it said in some circumstances where a decision is withdrawn, that decision may continue to have some form of effect for the purpose of Section 3C leave, for example. And so it may not be that leave is extended retroactively under 3C from the purpose from the point of that decision onwards. And that might not make a lot of sense in the abstract. But one of the things that I said in my book, which I'll talk about more in a moment, and don't worry, this won't be a sales pitch, is the importance of ensuring what the effect of a withdrawal is when bringing a judicial review claim. So the importance of, in any consent order, setting out that the effect of a withdrawal is that the application of X date remains undecided. Because if that is correct, then there's no lawful decision on that application until the subsequent decision is made following the withdrawal. And it's from that date onwards that either 3C leave kicks in or leave to remain ends, or whatever it is that needs to happen. But it protects the period, particularly from the making of the now withdrawn decision to the future, but also that period while that application was pending. So in the abstract, it might not be particularly helpful. It was something that helped us in the Court of Appeal in the case of ACTA, which is the top citation in the next slide. So in this case, we successfully argued that there was a proper claim that a human rights refusal emanating from one single application would extend leave to remain, even where a decision had previously been made. So basically what I was talking about in terms of Akinola, where a decision had previously been made, but in certain circumstances. So those circumstances, as I say, could include where there's been a proper consent order saying the decision is withdrawn, the application remains undecided for subsequent decision, but it could be some other circumstances as well. And that was something that we were able to argue in ACTA. I've got to say, in ACTA, I only got involved once it went up to the Court of Appeal, so I wasn't involved in earlier proceedings. And in fact, the period that we were talking about with previous decisions, etc., predated my involvement by so many years. And so ultimately, unfortunately, in the subsequent judicial review, which went back down to the upper tribunal, we were unsuccessful for reasons other than the legal technicalities involved in this Court of Appeal decision. But we were able to succeed in the Court of Appeal in showing that that proper basis could be made out. I'm then going to take things slightly out of order, but when I go through why I'm doing it that way, it will make more sense. Going back to the Afzal case, so we saw reference to this earlier. This is how it was treated by the Supreme Court. And the question was, could leave to remain be disregarded for the could periods of overstaying that are disregarded count towards the 10-year continuous lawful residence? So the simple question is, if a period of overstaying is disregarded, can that period still count towards 10-year lawful residence? Because Afzal from the upper tribunal appeared to suggest that it could. The Supreme Court said no, it wouldn't. And that the word disregarded meant only that the bookended period of overstaying did not break continuity between the periods of residence, but that it did not continue the period of residence. So without the period of overstaying being counted for the purpose of that calculation. In this case, there was another comment on the poor drafting of 276B as it stood, and an interpretation of this case in the third case down on your slide, so the case of Ayeke. The interpretation of this case in Ayeke was that it had decided that book-ended leave did not count towards the 10-year period of residence. So it essentially overturned what was found by the upper tribunal in that case. Well, let's look then more at what Ayeke says. The question was whether an appellant has had at least 10 years continuous lawful residence in the United Kingdom, where there's been a gap of 111 days as a period of overstaying between periods of leave. So a bookended gap of 111 days. And the question is whether that, having been disregarded because it was bookended, would also be counted towards the 10 years lawful residence. And the court found that it wouldn't. There was an argument that Afzal had been incorrectly or wrongly decided, and that argument was rejected in Ayeke. So that particular argument failed. And then the last case that I'm going to refer to is the second case on the slide. It's the case of Ali. And it basically talks about the effect of applying within the grace period. So at the time of Ali, the grace period was 28 days. Now it's shorter. Paragraph 39E provides for what that period is. The question essentially was whether applying in that grace period means that an application was in time. Of course, whether an application is in time or not is important for the purposes of continuous lawful residence, and the court found that it wasn't. Therefore, a subsequent application that was made within the 39E period, so again, if it's 28 days at that relevant time, within the 28 days, couldn't be considered as an application that was within that 39E period, even if it was within the 28 days, because the original application was not in time. So for 39E to bite, the previous application has to be an in-time application. You can't effectively have two 39E periods of applications or of applications after refusals, because in order for 39E to bite, the previous application has to have been in time. So that's essentially a summary of what is said in the case of Ali. Now, I've made a couple of references already to the fact that in 2022, I wrote a book about long residence. It was a practical guide to long residence applications under the immigration rules. Normally, this would be the part of the seminar where I try and flog it and try and get everyone to buy it. But I'm going to say something odd now. And I'm going to say don't buy it because it's completely out of date and it won't help you. Even if you've got an application that's caught by the transitional provisions, you're better off not buying this book because case law's moved on in any event. So forget the fact that the statutory provisions have moved on, the case law has moved on. So although I did write a book about it, it's completely academic now and it's not worth buying. So please don't buy it, even if you see an advert for the book online, which hopefully you won't do from me because I've stopped advertising it. I stopped advertising it a long time ago. So that's everything from me. Thank you to all of you for listening. Thank you to the organizers of this wonderful event. I hope that's been helpful. There are a couple of questions in the Q&A box that I'm going to look at now. So let's have a look. So Regina's question is a specific question about the position of a spouse of a settled person who is self-employed in the UK but works outside of the UK for most of the time. It really depends on the family circumstances, where the original applicant resides, and what the purpose is of the other individual's absences from the United Kingdom. You'd have to have a look at I'm just putting up CR 3.1 and what the periods of absence are, etc.
Sorry for interrupting, Rajiv. I think this question, the time was 2:24 p.m. I think that was while
okay.
Doerfel was talking about business compliance.
Okay. Well,
but I think the one from Tahir Pasha is definitely for you, the longer question.
Right. Okay, let me just pull up the provisions. We've got a fairly lengthy question there. So one of the points that's brought in by these new immigration rules, specifically 11.3, as I referred to under the explanatory memorandum, is the requirement for an individual to have had permission on their current route for at least 12 months on the date of the application, or to have been exempt from immigration control for the last 12 months. So where an individual completes 10 years lawful residence in the appeal process, unless the permission to be in the UK was on long residence, which it won't have been if they've only completed that period subsequently, they won't qualify under this route for settlement, but they will qualify for what was referred to as permission to stay. So essentially what the point of the permission to stay route is for those individuals who don't qualify for settlement for one or any other reason in terms of what the requirements of the rules set out. They are able to get permission to remain for a bit longer and essentially give them enough time to be able to satisfy the other rules, be it the 12-month grant of leave provision, be it, because it's 24 months under this route, be it the English language or the knowledge of life in the UK. Yeah, I think the question, the second part of your question is, does it require an additional year? Yes, it does. That's exactly what the explanatory memorandum says in terms of them either being on this route for an extra year or having been exempt from immigration control, which doesn't mean, I'm not sure if your question is suggesting having been granted under any other route means being exempt from immigration control. the reason it's fair is because, well, that's the purpose of the change. One of the purposes of the change to the route. It's specifically set out in the explanatory memorandum, which is that they want individuals who qualify for settlement under this route to have been granted leave to remain under this route originally, and it does in those circumstances impose an additional year.
And I think that's probably it, Rajiv.
There's another question in the chat.
Oh, sorry, there is. I beg your
Although it's a
pardon.
slightly different topic. So that's a different route for settlement. It's an ILR route based on appendix family life settlement. And if it's an individual, let's see what continuous residence requirements are set out for them. There were some exceptions. What I'd suggest is this: have a look at the exceptions for residence applications, continuous residence applications under the continuous residence appendices, and the answer will be found in there. If it's an application that's out of time, that looks like it's probably bookended overstaying, but it may be overstaying that can be disregarded as long as the remaining 40 days can be made up through a different grant of leave, which usually under the family life route it can be. I think now that's effectively an answer to all of the three questions that we had. Richard, I can hand back to you then for the time being.
Oh, I think there are a couple more questions. I've been scrolling on down again, and one is about the correct application form for the 10 years continuous residence. And another attendee says, I can't see the questions after 12:44 p.m. So in fact, the most recent question was 2:57 p.m. and going back to 12. Oh, there's 12:40, the one about Afghanistan. Oh, I should have started my video, sorry. Yes, there's a question that we've dealt with. It was typed in at 12:40 p.m. and the person now is saying he can't see the questions after that one. Not sure if everyone is having this issue. And
Sure, I think I may be able to assist. It looks like there was a question at 12:44, which was the last question answered. If the individual looks into the Q&A box, there are three options at the top: open questions, answered questions, and dismissed questions. If they click from answered to open, they may be able to see the current questions.
Oh, I see. Yes, I hadn't noticed that difference.
No worries. Thank you.
Thank you. Oh, well, that should do the trick. Anyway, I think the only question then for Rajiv would be the one about the correct application form for the 10 years continuous residence. It would be an online form, of course.
It's an online form. I'm on it at the moment, www.gov.uk/long-residence. And you can apply on the form online there. It sets out information in relation to the fee, etc. Yeah, if there's another question there about rejection of an application, I think that means rejection as invalid. If an application, if any subsequent application is made under paragraph 39E, and paragraph 39E bites, and that will be fact sensitive, then it may not break continuous residence, but it depends on the basis of the application.
Oh, right.
Imprisonment breaks continuity of residence, and that's another question that has just come in now.
I think
what I'm going to do, I'm just going to tick off these questions that have been answered. Okay. So yeah, I will then hand over, Richard, back to you.
Yes, I think that has covered everything. Well, thank you very much, Rajiv.
Thank you.
And it's something which I think most of us find rather difficult to get a grip on, and you really clarified things for us. I hope you'll be able to stay for the panel discussion. But first of all, we've got our tea break, and that's meant to be for 10 minutes. We're just a little bit after 3 o'clock getting started. So let's reassemble by 3:15, and then we'll hear the final talk from Julian, followed by the panel discussion. So see you back here then at 3:15, everyone. Being asked to start, I hope Jan and Rajiv are available. I've just had a look at the Q&A box and the chat box, and there is one question in each of those which has not yet been answered. I don't think there's anything on. Anyway, we'll have to save that for the panel discussion. And now it's Julian's turn again, and I'm sure you'll be exciting some questions during this topic, adult-dependent relatives, which many of us find very difficult to succeed in. So without further ado, over to you, Julian.
Right, welcome back, everybody, and I hope everybody's still got enthusiasm for the last session of the day. I will do my best to make it as exciting as possible, and I shall just have a go at sharing my screen. Here we go. Right, I think there we go. All right, so you should all be able there to see the adult dependent relatives slideshow. I will go through these one at a time. But the first thing to say is that the adult dependent relative rules have changed very, very considerably over the last 20 years or so. So when I first began doing immigration law, these were the easiest of the applications for family members because the qualifying criteria were, was this a parent over the age of 65? That was pretty much it. Obviously now I think that they are genuinely amongst the very hardest of the family member applications to make. And of course, they do predominantly apply to elderly parents. The typical situation is that somebody is living, working, settled in the UK. They maybe had been here for 10 years or so when they left their country of origin to come and live and work in the UK. Their parents were in good health, and that is no longer the case as a result of age or illness. Those parents now would like to be unified with the adult child, the worker in the UK. And the question for that family is, well, does the worker in the UK leave, go home, look after their elderly parents, even if they have been here for very many years, even if home for them really is right here, or does the dependent relative come to the UK? And the Home Office rules have adjusted so that where it used to be assumed that of course, an elderly parent could come to join somebody who was contributing to the UK by living and working here, that has adjusted now. But that leaves a lot of sponsors in the UK in a very awkward position because it's often, in fact, I think mostly, just not as simple as upping sticks and leaving and returning to a home country that that person may not have been living in for some considerable time. There may be issues of children at school. There may be issues which would also engage Article 8, of course. They may be living as a blended family. How do you leave half the children here and the other half might come with you? These are all things that need consideration. So let's look at the potential pitfalls and how to achieve the best prospects of success in this increasingly difficult area. We'll start with the rules themselves. Now, for many of you, this is just going to be a matter of refreshing your memory. For some of you, you may not have seen these before, you may not have had cause to do them. So we will go through the rules and have a look at the shape of those and how they work. They're contained, as many parts of the immigration rules are now, in an appendix. Appendix, the imaginatively named Appendix Adult Dependent Relative. It's for a person aged 18 or over, so you cannot have a dependent relative child. Those come under a different route. So aged 18 or over who is sponsored by a relative in the UK, and that relative in the UK must be British, settled, have protection status, or be a specified EEA national with permission under Appendix EU. So this is not an available route for people who have temporary permission to be in the UK. If you are here as a Tier 2 health and social care worker, then you will not be able to sponsor a relative in this category. And additionally, the sponsor must be able to maintain, accommodate and care for the applicant without reliance on public funds. So that is the requirements for the sponsor. The applicant themselves must require long-term personal care to perform everyday tasks due to age, illness or disability. So that's quite a stringent criteria there. Long-term personal care to perform once a week tasks won't do. It has to be everyday tasks. And the long-term personal care must be required due to age, illness or disability and not for any other reason. And the care must be either not available or not affordable in the country where the applicant is living. And those of you who've done these applications or who are highly attuned to the immigration rules will immediately spot there that there is something of a catch-22, because if you cannot afford to fund care in the country where the applicant is living, as a general rule, although not a universal one, it would be extremely difficult to fund that care from the UK, where care is expensive. So let's look at validity requirements. The first of these is you must be outside the UK. You cannot switch in country. We will come back to that in the potential pitfalls and how to overcome them. But that is the principle in the immigration rules. You must be outside the UK to apply. You must pay the fee, the immigration health charge, provide biometrics, and provide a passport or other valid ID, although the reality is that that needs to be a passport. Suitability must not fall for refusal under the suitability grounds set out in EC 1.2 to 1.8 or 2.2 to 3.2 of Appendix FM. That's fairly straightforward. I shan't take you all through the suitability rules. They're set out quite clearly there in Appendix FM. And the applicant must not be in breach of immigration laws or on immigration bail. Then the relationship requirement. This is not a mechanism by which you can bring any adult dependent relative. The adult dependent relative must be the parent, grandparent, son, daughter, brother or sister. And this is a relatively recent change. It must be of the sponsor. That used to include relatives of the sponsor's partner as well, and it no longer does. The sponsor must be British, settled, living with protection status, or an EEA national. And interestingly, and again, this is something that has come up relatively recently, it must be the same sponsor on application for extension. So what you cannot do is to invite the grandmother to come and live with sponsor number 1, and then he looks after her for 3 years and then shuffles her off to sponsor number 2, who looks after her for 3 years and shuffles her off to sponsor number 3, so that all the siblings get a chance to take it in turns. Yes, that must be the same sponsor. Again, we'll return to that in terms of whether there is any mechanism to navigate past that later on. And the dependency requirement must, as a result of age, illness, or disability, which we looked at earlier, require long-term personal care to perform everyday tasks. Now, there is a very useful shorthand for that in other areas of law. If you look at court of protection work, if you look at mental health work, if you look at special educational needs and disability work, you will find almost the same criteria described as activities of daily living. And those activities of daily living are what we are looking at here. It's the same ADLs, they're called activities of daily living, are the same sorts of things that they look at for PIP, personal independence payment. So it's things like getting dressed, brushing hair, sorting out dentures, taking medication, ear care, eye care, things that you might not even have considered would arise in the context of personal care. And then must be unable to obtain the required level of care in the country where they're living, even with the financial help of the sponsor, because either it's not available and there's nobody there to provide it, or the care is not affordable. Now, the affordable one, we will struggle a little bit with affordable, because there are relatively few countries in which the care is affordable in the UK, but the equivalent care is not affordable abroad. That might be the case in America, perhaps, potentially Australia. There will be other countries, potentially parts of the UAE, but you would have to get really good evidence, and it's by no means certain. And certainly it's not enough just to make the assertion that it's unaffordable. So quite often when we look at these, we're looking at whether or not the care is available and there's anybody there who can reasonably provide it. The sponsor must be able to provide adequate maintenance, accommodation and care for the adult dependent relative without access to public funds, of course, and must provide assigned maintenance, giving that as an undertaking for a period of 5 years, or however long the stay is to be granted, because if you're joining somebody who has limited leave, then the adult dependent relative also gets limited leave. And because it is a formal undertaking, do bear in mind that failure of a sponsor to maintain is now a criminal offence. So persistent refusal or neglect to maintain the adult dependent relative in breach of an undertaking is a criminal offence. And that is certainly something that I think comes as a huge surprise to a lot of people if they are on the wrong end of that. But before you think, well, what is the point? We can't possibly meet all of these criteria. There is, I don't want to call it a safety net, because we know from case law that Article 8 is never a safety net. But there is a little bit of inbuilt flexibility, ensuring that the rule is Article 8 compliant. And that is ADR 7.1. If they don't meet all the suitability requirements, or don't meet all of the eligibility requirements, but refusal would result in a breach of Article 8 because it would result in unjustifiably harsh consequences, then they can still come in on Article 8 leave instead, on the basis that it would be unjustifiably harsh if they were not granted entry clearance. So what does the guidance have to say about this? The guidance, as you can probably imagine, is pretty long. It's the most recent version is 7th of August 2023. It's version 5, Family Policy, Adult Dependent Relatives, and it's on the usual assets.publishing.service.gov.uk site, easily located through Google. And it is, I have to say, one of the less outrageously lengthy ones because it's only 24 pages long, although there are, of course, links through to other parts. Guidance can be really, really helpful when you are writing a cover letter, because if you can draw an analogy with a situation envisaged by the guidance, that will provide significant weight behind the application that you're making. So what I've done here is just to draw out a few key paragraphs, which might come in handy for applications being made. So one is that they give examples of what might constitute everyday tasks, long-term personal care to perform everyday tasks. For example, washing, dressing, and cooking. That's useful because it gives you a steer when you are seeking medical reports, potentially from somebody who is not accustomed to writing medical reports for the purposes of legal applications. If you say long-term personal care to perform everyday tasks, that is translated into another language, and the doctor is looking at it blankly, thinking, well, what on earth am I being asked to do here? Having a steer as to what it might be is helpful. The required level of care, a matter to be objectively assessed with reference to the specific needs of the applicant. And you'll see there that I've underlined the part that says, so this says the level of long-term personal care must be what is required. So we need the word needs in here. What are their care needs? We would refer to that in other areas, in light of their physical needs, but also any emotional or psychological needs. And that, I think, is really, really crucial, because alongside age, illness, and disability, often arises mental health or psychological needs, which in turn need to be addressed. So it is not sufficient simply to say, well, this person can have their washing, dressing, and cooking done for them by a third party, if that will not meet their psychological needs. Of course, evidence provided by a doctor or other health professional. Other key passages from the guidance. If you are arguing that the care is not available in the country, as opposed to unaffordable, so if you're saying unavailable, the entry clearance officer has to look at whether it's realistically accessible to the applicant. Consideration should be given to the geographical location and the cost of such care. So if you're saying, well, there is one care home in the entire country that caters to this particular medical need, but it's 4,000 kilometres away and everybody there speaks a different dialect, then it may not be realistically accessible to the applicant in a way that it would be if there is one in the large town nearby. And then the provision of the care in the applicant's home country must be reasonable, both from the perspective of the provider of the care and the perspective of the applicant. Now, I'm going to come back to that one because, again, I think that is absolutely key. It's not, of course, sadly, for those making applications, that is not essentially an applicant's right to choose who provides their care. But it certainly means that the entry clearance officer cannot impose a particular type of care against the applicant or that carer's wishes. So, for example, if you've got somebody who is grudgingly going in once a day and helping an adult dependent relative, but has made it clear that this is not going to be a long-term arrangement, then it needs to be reasonable from their perspective as well. It won't be adequate for the ECO to say, well, we can just keep doing that. Then we have evidence that care is unavailable, should be obviously from a central or local health authority, a local authority, a doctor or other health professional in the country in question. So again, assertions have no place in adult dependent relative applications. It does need to come from a credible and reliable source. And medical evidence about the adult dependent relatives' care needs must be from a doctor or other health professional. That is exactly what you would expect, but it doesn't preclude you from also putting in the witness statement from the sponsor saying what their views are. So what about potential pitfalls? What are we dealing with there? What are the most common ones? So here are some of the common issues that I've encountered. And one major one is that the need for the application was not apparent whilst the adult dependent relative was abroad. So you have a situation where the adult dependent relative comes to the UK for a visit, has joined typically their son or daughter, intending to stay for 3 months. And during the currency of that visit, the son or daughter gets increasingly concerned that the elderly parent, had been saying that they were absolutely fine, managing, and in fact, they are not managing. They have serious and increasing difficulties with their memory. Or they're in the UK and they have a major incident, such as a stroke. Because, of course, the rule is that they would still have to leave, return to their home country and make their application to come back to the UK. A second common issue is that there is no problem with the availability of care in the country of origin. In fact, the family are funding a carer. The carer is going in, he or she is available, he or she is affordable. And therefore, on the face of it, the rule is not met. But the adult dependent relative is rejecting that care. That is particularly common with dementia. The patient in that case may accuse the carer of stealing from them. They may not recognise them. They may become extremely rude and just slam the door in their face and say, you're not coming in. And that is not uncommon. That is a known effect in dementia patients. A third common issue is, again, the care is there, it's available, it's affordable, but the current carer has had enough. Particularly an issue where the care available is from family members in the country of origin. Or from next door neighbours. So there isn't any formal care like a care home or day nurses, night nurses, anything like that. But the person could probably cope quite well. The needs would be met if they just had someone pop in twice a day to check on them. So far, that has been being done by another family member or a near neighbour, and that person says, I don't want to do it anymore. I've got too many of my own responsibilities. Again, on the face of it, the rules are then not met. So how do we repair this? And what is another common problem? Another common problem is that the person does meet the rules, but it hasn't been properly evidenced. And the main one, of course, is this double-edged sword built into the rules. If you can afford to pay for care in the UK, how are you seriously saying that you can't pay for it anywhere in many other countries in the world? Obviously, there are some, but predominantly it is cheaper to get to access medical care, private medical care at least, in many other places. So, because this is the last session of the day and everybody has had their lunch and is starting to feel sleepy, I thought what we could do at this point is to add some suggestions into the comments, if you want to, for those who have done these before. Let's just take 5 minutes to share any other pitfalls that you may have encountered. So I'm going to stop sharing briefly whilst anybody contributes any other pitfalls, because then we can deal with those together as we go through the next bit. So I'm going to open up the Q&A box, and this is going to be very slightly embarrassing if nobody actually has any other pitfalls to share. So let's see if we have any others coming in at this point. I can see one question that's come up just while people think of any pitfalls that they might identify. So when an applicant is in the UK and is taken ill in circumstances which mirror ADR requirements, what do you do? Suffered a stroke in the UK. This is something I've seen before and was going to address in the next part. Absolutely, we will do that bit. And then what happens if parents come to the UK on a visit visa and make an application here in breach of the rules? The plus point, the Home Office doesn't detain or quickly remove elderly parents, is the right approach to make an application here. So those two questions are two sides, I think, of the same coin. But one, I think, perhaps is a genuine unanticipated emergency. The person is fine, then has a stroke. The second is perhaps more of an attempt to circumvent the rules in that they knew when they made their application for a visit that they would not be returning. And then a question, this isn't really pitfalls, but what's the level of maintenance fund? And we can look at that too. All right, well, I'm going to start sharing my screen again, and we can go through some of the remedies to these pitfalls. Here we go. So, maximising prospects of success, how are we going to do this? And this is the one on in-country applications. It's a very helpful case, TZ Pakistan and PG India, from back in 2018. And this says that where a person satisfies the rules, whether or not by reference to an Article 8 informed requirement, this will be positively determinative of that person's Article 8 appeal, provided their case engages Article 8.1, which these cases almost always will, for the very reason that it would then be disproportionate for that person to be removed. The long and short of that paragraph in that judgment is that if a person satisfies the rules, removal is disproportionate. So what I would do, and this is in relation to Abdur Baba's question as well as for the purposes of this presentation, if you do have a relative who comes into the UK without any long-term personal care needs and then has a debilitating stroke, what do you do? And I would say, yes, the application can still be made, notwithstanding that they have the wrong type of leave. Because even though you don't meet the rules, you've got two potential options here. One is that you make the application and you say, we don't meet the rules because we don't meet we're here on a visit visa, but we can go back to, as you recall, the Article 8 exceptional compelling. The other alternative is to say, or additionally to that, you can also say, look, TZ and PG says that if we meet the rules, that's positively determinative on an Article 8 basis. So we're inviting you to grant leave outside the rules on the basis that we do meet the rules. That sounds slightly topsy-turvy, but it means that if you can show that you do in fact meet all of the criteria, save for that one, essentially very similar to a Chikwamba point, it is then open for the tribunal either to say you meet the rules, that's positively dispositive of the appeal, or to say, well, you meet all but this rule, and therefore that is a strong indicator that it should be allowed under ADR 7.1, the Article 8 flexibility point. And in fact, whilst I'm on that, that would be the same technical answer for the adult dependent relative who is taken ill, and the adult dependent relative who was already ill and knew perfectly well that they weren't returning. Certainly, coming to the UK and overstaying the visit visa would be a worse option than making the application in the UK if that is what you are faced with. Obviously, if they come to you on a visit visa and they are capable of returning to their country of origin and making the application for entry clearance, that is what they should be doing. But if they come to you at the end of the currency of that visa, as in, they're risking, or they are already an overstayer, and they're seeking to regularise, then in principle, it's probably making the application on Article 8 outside the rules, but within the rules under that flexibility is likely to be the most pragmatic solution there. Care rejection is the next one. Although as I'm just flicking through the Q&A, I can see a very apposite comment from Agnes. If you're switching from the visitor, you must address the potential allegation of illegal entry. This is absolutely the case. If somebody's come to the UK and had a sudden stroke, it might be that your explanation is extremely short. This was unanticipated. If it looks as though actually they may not have been being 100% straight with their application as a visitor, you do need to address it head on in the cover letter. Because if they are refused, as Agnes quite rightly says, they will never come back in as a visitor. This is double or quits to make an application where you are essentially outside the rules because you don't have the immigration status. So be careful with that. But if they meet the rules, then yes, you can rely on 7.1 and on TZ and PG to make the application in country, even though technically you shouldn't. All right, now this next one probably answers Winston Taylor's point. Son with ILR, mother is in India, cared for locally by the neighbour providing limited care, but the mother insists on being cared for by the son. Now, obviously, I don't know for the specifics of Winston's situation there, whether or not what the mother's particular age, illness or disability might be. But care rejection, where a patient insists on being treated or cared for only by known family members, is not an uncommon issue. It's relatively frequently seen in dementia patients and others who have cognitive decline. So there are also other conditions that cause cognitive decline. It's a real problem where the Home Office view will be quite rigid. The care is available and it can be funded by the sponsor. And as far as the entry clearance officer is concerned, that's it. Case closed. But obviously from the sponsor's perspective, the difficulty is that the adult dependent relative simply will not open the door. And I have seen extreme circumstances of that where they might in fact be physically or verbally aggressive to the carer, particularly if they have paranoia as features of their cognitive decline. Now, it is possible to be successful on these as long as you have proper evidence. But really, the key here is proper evidence. So there will need to be evidence of the nature of the care rejection. What is causing it? Is it dementia? Is it cognitive decline? Is it depression? Is it something totally different? And you will, in reality, you will need a geriatric psychiatrist to assess the adult dependent relative. and assess the level of care rejection. Could they form a good relationship with a trusted carer if they were introduced slowly, that sort of thing. But I have been successful in a number of cases on care rejection, and that goes back to that section in the guidance that the care must be acceptable to the adult dependent relative, to the patient, and also to the carer. So if you have somebody who is physically or verbally aggressive to the carer, or even somebody who will not let them in, but also will not take their medication or look after themselves, then that care is not reasonably acceptable to both the patient and the provider, and it is not meeting their needs. And that is that phrase that we need to keep coming back to, as we would in a PIP appeal, as we would in mental health, as we would in other areas. Is this capable of meeting their needs? What about if current care cannot continue? So this is perhaps a step down from somebody who's actively care rejecting. Again, not enough just to make the assertion. It needs to be more than that. It must be properly evidenced, and it must, if at all humanly possible, must include a sworn statement from the existing carer saying why they can't or won't do it any longer. In some ways, the reason that they give is less important than that they give a reason, because people refuse for all sorts of reasons. And if pragmatically they are no longer willing to provide it, then they're no longer willing to provide it. And whether the entry clearance officer thinks that that's a selfish perspective is neither here nor there. They're not willing. They're not willing. And again, that goes back to that section in the guidance that it must be reasonable from the perspective of the carer and the adult dependent relative. Because if you have a friend or a family member or similar there, then and they're not willing to do it, you've obviously also got to meet the other parts of the criteria, that it's either, you know, if that carer were to stop, is there anyone else who could step in? Is there a care home available? In some countries, of course, there isn't. And it is sometimes possible to get evidence, particularly from former Soviet Union states, where the person will be declined entry to a care home purely because they have able working sons or daughters who should be according to their own laws, providing them with care. And that, of course, can also be very helpful to show that the care is unavailable, even if it is in principle available, if they cannot get a place there because they're not eligible for one. And then another is funding or availability of care. So where you have somebody who is reasonably well off, they have the funds, they're willing to insure privately the adult dependent relative, that's going to cost quite a lot. They're willing to have a private carer or nurse pop in twice a day to check on medication and do a bed bath or whatever the person might need. That's expensive. So the entry clearance officer is likely at that stage to say, well, if you can afford this here, why can't you afford the equivalent there? And that must really engage with the options that are available. If there are no care homes, then we need proper evidence saying so, not a single sentence in a witness statement saying there aren't any. If there are care homes, but the adult dependent relative is ineligible for them, then we need that evidence. They would need to make the application and get the rejection, ideally. If there are care homes, but they only provide physical care, this is quite a common one, where if somebody is simply old, they will provide care, but there is very limited dementia care, for example, evidence of that too, but it must be properly evidenced. It's obviously a simpler application if a particular treatment is needed and is just not there, not available. So you can probably guess the next slide is how to tie all these ends together, and it is evidence, evidence, evidence. So what I've said here is that your application is a leaky pipe. You've got to get your application from up here, where the application goes in, all the way through this leaky pipe to the end without any of it falling out. So your job is to think in advance where those leaks are and plug them, get them mended. If you ignore the leak in that pipe and hope it goes away, your application will fall out of the pipe before it gets to where it needs to go. So as a minimum, you are going to need a really good cover letter. Counsel are often quite happy to assist with drafting, reviewing cover letters. Do let us know if we can help out with that. Really good witness statements where appropriate. Yes, these applications are quite dependent on medical professionals, healthcare professionals, objective evidence about the availability of nursing or care homes, but that doesn't mean that we don't need a witness statement. Medical evidence from the treating team. You can't go in there just with one report from one person, however good they are, who has seen the adult dependent relative for an hour, because the entry clearance officer or the presenting officer at the tribunal will say, well, where's the evidence from the people who really know this person? So you need medical evidence from the treating team. By all means, top it up with the relevant specialist evidence. So, for example, a consultant psychiatrist who is able to assess what the person's ADLs actually look like at the moment, whether they are care rejecting, what is causing that, what their care needs are. And in the reports, it is vital that they talk about not what would be nice in the best of all possible worlds. We are not looking for an ideal here. What are this person's identified care needs? What will meet their needs? Because we are looking at requirements here, not anything other than that. And if the adult dependent relative has dementia and you are making a case that they are care rejecting, that external support or care is not an option here, then you must make it clear with the medical evidence that only family care, support from familiar people will meet their needs. So just finally, I've just popped down 3 potential and useful professionals. Independent social worker. If it is the adult dependent relative's case, if it is your case, that the relative is not currently caring for themselves very well, perhaps they're not living in great circumstances, then an independent social worker who specialises in old age may well be able to assess them via video link, assess the family in the UK, talk about what their needs are from a care, health and social care perspective. That is only from a social care perspective rather than exclusively from a health perspective. But psychological needs are still needs. They are not excluded from this. Geriatric psychiatrist, if your client is suffering from dementia, Alzheimer's, cognitive decline, Parkinson's, any of those things, even if the issue is really depression and anxiety. So you might have somebody whose illness wouldn't in and of itself require them to need long-term personal care. Say, for example, that they are being treated for cancer. But the effect of the illness and the isolation has caused them to slip into such an extent of depression and anxiety that they are now at the care rejecting, unable to care for themselves level. The depression and anxiety is a care need in and of itself, and a psychiatrist will be able to assess that and say what those care needs are. And then finally, an occupational therapist is often very, very useful because that person is able to assess their capacity at the moment for activities of daily living, the ADLs. And obviously, if their conclusion is that the relative is unable to meet their ADLs, then that is something that can be very useful. So that is the end of that talk. I'm just going to have a quick look at the Q&A before we move back to the panel. Koshi has said parents are wealthy and would, prior to withdrawal of adults of independent means, have satisfied this requirement. ECO refuses on the basis that parents can afford private care. Unfortunately, yes, that is exactly the type of situation that the rules now don't help with. So if they can afford private care and the private care they can afford meets their needs, then they cannot succeed on this route. It's only if the private care they can afford doesn't meet their needs because they have social care needs or they have care rejection problems or something similar to that, that you could introduce that separately. But otherwise, I'm afraid that would not succeed.
Oh, the host asked me to appear on the screen. Now, the thing is, there are still a number of questions on adult dependent relatives. We're supposed to be having a panel discussion, but I think most of the outstanding questions are for Julian. So I think, Julian, you can just carry on.
I'll just carry on. I think I've
answering.
answered some of them as I've gone through. So anonymous attendee was the one with the stroke whilst in the UK. So that one has been answered, as has Abdul Baba's question on entry and then application in country. What is the level of maintenance fund? So it's set out in paragraphs 1, 12A and 12B of Appendix FMSE. So it's essentially the same FMSE as anywhere else. But of course, you've also got the added issue that they should be privately health insured as well. And then there's a question from Tahir Pasha on the issue of affordability of care. Could it be addressed where a family member in the UK, such as sponsor's wife or adult children living in the same household, are able to provide that care without any costs to the family unit, and it's not otherwise affordable in the country of origin? Yes. So if they can afford to meet the Appendix FM maintenance requirement, and there is an adult in the UK who is not currently working, living in the same household, able to provide care, and that they would not be able to afford the care abroad, then yes, absolutely, that would be perhaps, I'm going to say perhaps the only route other than where care is actually more expensive abroad. So yes, that's a possibility too. Level of maintenance fund we've dealt with. And the parents affording private care I've dealt with too. Agnes' comment we've raised, and the same with Winston's question about the mother refusing care. So I think most of those, I think we managed to do as we went along. Yes, I'm back in the long residence, which I would need to hand back to Rajiv for.
Now I've only just spotted on my phone, which I turned to silent in case it went off during the session, a number of messages which I've missed from our host. And one of them is that Rajiv hasn't been able to stay. He had to go and pick up his son from school. So unless one of us can answer it, are you looking at the question from Tajamal Butt?
Yes.
Yeah, quite
I
a
don't
long
know whether
one.
that was answered or not.
Mhm.
But I can answer, just whilst we think about that one, I can answer the follow-up question from Tahir. For an in-country application, would you recommend specifically inviting the Secretary of State to consider ADR with reference to Chikwamba? Potentially is the answer to that. I'm going to do the classic lawyer's answer, it depends. If you have someone where they plainly cannot return and make their application from abroad, it might be worth mentioning Chikwamba. But otherwise, I don't think you need to risk a Chikwamba analysis, because you do have that exceptional circumstances built in into the rule itself. And you can also reference that case that I mentioned, TZ, and say, look, if they meet all of the rest of the rules, save the requirement to leave and come back, that should point to the strength of the proportionality argument in their favour, that they do satisfy Article 8. And if they satisfy Article 8, then they satisfy the text of that rule, which includes that flexibility built in at 7.1. So I think that I would frame it in terms of 7.1 and the TZ case law, rather than going down the Chikwamba route, which of course got rowed back on slightly.
Yes, there was a case, was it Alam, where the Court of Appeal tried to narrow down very much the scope of Chikwamba.
Yes, I can't remember if it was Alam or one of the others, but there was certainly one where they said Chikwamba, they didn't quite say Chikwamba is being used and abused, but they certainly said it was only for situations such as was envisaged in Chikwamba, where she simply could not return to Zimbabwe safely and sensibly and be back in a reasonable amount of time. But it's not a shortcut to somebody who would otherwise leave for 3 or 4 weeks and be back.
Yes. And from what you've been saying, I agree. It's well worth pointing out that Article 8, as included in Appendix ADR, it doesn't have the requirement of exceptional circumstances. You just have to show that it would be unduly harsh on the applicant and the members of her family if she isn't allowed to be in the UK or stay in the UK if it's an in-country application.
Yes, it's unjustifiably harsh consequences for the applicant or their family. So it's not restricted to the applicant themselves.
Yes, yes. Oh, I'm afraid I don't think I'm up to answering this long question from Mr. Butt. I think we would need Rajiv to answer.
I wonder if Brenda or Jan, if they're there, might like to, we could do a collaborative effort on this. So it's the applicant entered the UK in 2012 as a Tier 4 student, got an extension to 2014, applied for further leave before the expiry of his then leave to remain, and didn't get a decision until now. Subject access records show that a decision had been made in 2018 but never served on the applicant. The applicant made a set long residence app in 2023, refused based on the refusal in 2018. Would there be merit? Do you know, I can contribute to this because I have had a very, very similar situation arise. And the answer in my case was it's going to depend whether it was never served because the Home Office forgot to serve it, in which case he's still got Section 3C leave, or whether it was never served because he was on bail and absconded, in which case serving it to file is an acceptable method of doing it. So I think you would need to delve a little deeper into why that was never served on the applicant. If the subject access request is silent on it, then I would say it should be decided in the applicant's favour, give him the benefit of the doubt. But if it says he went missing, no longer at the address he was at, and therefore served to file, I think you would find it harder.
Well, I think you've nailed it there, Julian.
Yeah, and I can see David Nelson has added it's not effective till it's been served. That is correct, but my understanding is that it can be effectively served to file in situations where the applicant has absconded. But they have to have actively absconded. It's not enough that the Home Office can't, sent them a letter and never heard anything more. There has to be a reason for that, unless that has changed, which potentially it could have done.
I think it's the same. Now, is there still anything that we haven't covered? Let's just scroll up a little bit.
Could I just make one point on Julian's excellent talk?
Oh, sure thing.
Yeah, marvelous. Yeah, fantastic outline and a detailed overview. Absolutely incredible. I think it'll help everyone enormously to put applications in. One point in relation to applications made from within the country, so more the scenario of someone coming in and then falling ill, or relatives realizing how much worse the person actually is than they think. I think it's always worth instructing consultant psychiatrists to assess whether there are very significant obstacles to the reintegration in their country of origin. For example, in dementia cases, but also particularly physical illnesses, someone who's had heart attacks whilst they're here, clearly unable to work, and in dementia cases, clearly unable to understand the workings, etc., or, unable to function literally at all without help. I think then the very significant obstacles point is usually met. I mean, certainly all the adult dependent relative cases I've done with excellent consultant psychiatrist report have all found that that is also met. I certainly agree that if someone comes in and then makes the application from the inside, there is a risk, especially if the person is sort of mentally fit, that the Home Office might make the point that this is all planned. I've had a case, it was some years ago, about a 92-year-old South African lady that then hit the news. It was Murto Cothill. We started a whole petition to actually reverse the changes in the immigration rules, and that was signed by over 200,000 people. I think at the time, both the tribunal and the Home Office were very unsympathetic because they thought she'd sold everything in South Africa, then came to live with her daughter, who was a carer, and then refused all the way. We managed to turn it around because we had significant media attention, and the self-check and removal directions by the Home Office were followed by a call by the Home Office, then having realized how much they'd shot themselves in the foot, with, have you got any further submissions? And of course, we had a very good consultant psychiatrist report at that point. Yeah, so I think it is definitely always a struggle making those applications from abroad. And Julian has given all the details. First of all, it's one of the highest application fees, of course. It's absolutely extortionate. Secondly, I think the Home Office, I've been instructed on appeals, and with consultant psychiatrist reports, we've managed to then overturn the refusals. But when you have someone who's already very ill, and then you add another 1 year waiting for the appeal hearing. I've certainly had some ex-colleagues of mine whose clients died in the meantime. So yeah, it's quite a difficult position to be in. But I certainly would advise clients who certainly have concerns when their relatives have joined them here on a visit visa, and they're suddenly shocked about how far their mental state has deteriorated, for example, in terms of dementia, to then get a psychiatrist report to assess in how far their human rights would be violated if they were removed, i.e. to ask all the questions that Julian has set out, including whether there are very significant obstacles to their reintegration. So I certainly think these cases can be won, but the evidence has to be of a fantastically high quality. And so do the instructions, in my view. It's not sufficient to just let the doctors figure out what tests they effectively have to apply. but to give them some guidance as to, for example, even what amounts to very, what do they have to assess when they look at very significant obstacles. And as Julian has said, to use, for example, the PIP criteria, which I've also done, so that the medical report, if leave is then granted, can be used for subsequent application for personal independence payment without requiring a second report, so to speak. But Julian, your presentation has absolutely blown me away, and has put certainly my presentation to absolute shame. So well done.
Well, praise indeed from an expert. I absolutely agree with everything that Jan has said. Certainly, if the application is being made from within the UK, it's a good argument if you can show that the applicant would actually not be able to integrate in her own country if she goes back because of her mental and physical disabilities. And certainly very good medical or psychiatric evidence makes all the difference. In fact, it's something which I have occasion to deprecate when the applicant is abroad and is actually applying under Appendix ADR rather than is in the country and can't use that appendix and has to rely on, well, basically private life in the UK instead. Oh, and of course, she can't get indefinite leave to remain if she applies from within the UK. It's only somebody who applies from abroad under Appendix ADR who's eligible for indefinite leave. But anyway, going back to the point about medical evidence, the standard of medical evidence from overseas I've found to be very poor, actually. You want very good a very good account from the doctor who's personally seen the applicant and actually gives details about the things that she can or cannot do for herself. But quite often, it's apparent that the doctor is only just repeating what he's been told by the appellant's family, the applicant's family, and he's not really giving a detailed account of her medical problems at all, but just very vague things like, she can't do normal things around the house, but not specifying what exactly it is. So in those circumstances, the task is much harder.
The other thing that I would add to that as well, Richard, is that sometimes medical reports from abroad, not only do they just repeat what the person has said, which isn't very helpful, but they often trespass on the functions of the tribunal, which winds judges up. I don't know, Richard, when you were sitting, whether it used to irritate you as much as it clearly irritates many judges in the tribunals now. But I've seen so many which say things like, it would clearly be a breach of this patient's human rights if she were not permitted to come and live with her son in the UK. And you look at it and you think, oh no, because you know exactly how a tribunal is going to respond to that, and it's not going to be to embrace it. But I think the other thing to hear is just added is, should we invite the Secretary of State to consider very significant obstacles under private life? Yes, potentially, because that's all about their ability to maintain Article 8 relationships and so on as well. So certainly for dementia patients, yes. And the other thing that I would also encourage adding in, it won't be, I think, determinative, but could be persuasive, is the Convention on the Rights of Persons with Disabilities in those circumstances too.
You're quite right about, well, witness statements, which solicitors insist on including what are really pleadings, haranguing the tribunal about Article 8 rights and so on, which a layperson probably wouldn't know that much about. Oh, no, Jan, I think you've got another comment.
Just one point, yeah. Sorry, the light's very bizarre, but Yeah, definitely. I think that's where instructions to the medical experts are really important. You don't want them to stray into the authority of the tribunal, but at the same time, you don't want to withhold to them what they ought to be looking at. So I think it's always important and to use the terms whether very significant obstacles, having set out what the case law is of the tribunal or the higher courts, so that they know which functions to assess. Also, I think it's always helpful when you have a client who is here, whose condition has deteriorated, to ask the medical expert, whether concerned psychiatrist or other medical expert, to assess whether the person is actually fit to fly, and then to assess the interplay between mental health and physical health. So, for example, they might be suffering from asthma, but also anxiety, and how do these things interact when they're on a flight panicking? They know that they're now going to be removed from the ones they love, etc. So it isn't just the asthma or just the anxiety, but so forth. And if you have a good medical expert who can relate to the latest research about, in-flight occurrences, emergencies, etc., relating to medical evidence, etc., it's extremely helpful. Again, it might not be the central point, but it certainly will focus the mind on, well, if you can't remove the person anyway because they're unfit to fly and it would breach their Article 8 entry rights, especially if they have an emergency and they can't land. And I've had someone, for example, with huge heart problems where it was evident, and the medical expert said that out, that if they had cardiac arrest on the plane, they would not survive it. So I think it's important to have a lot in the medical reports, because of course we all know that consultant psychiatrist reports are not only worth every penny, but they are also not cheap. So you would want to be asking the right questions, and have them cover the whole field of relevance.
You're right about the quality of particularly psychiatric evidence. I once was instructed in a case where the psychiatrist was absolutely brilliant. I'd never seen anyone give better expert evidence, and I thought, well, this guy's done it on his own, and he'd hardly bother with making submissions. But they aren't all like that.
Well, exactly. I mean, that is the point, I think, because once you have a medical report that's unassailable, and the Home Office won't generally instruct someone else, although I had someone in immigration detention where the Home Office was then considering sort of re-evaluating that report, etc., and we fought back against that. Then the Home Office can't really take issue with the report.
Mm-hmm. Indeed. Oh. Well, folks, I wonder if we have reached the witching hour of 4:30. Not quite. I think there's maybe time for a couple more questions in the panel discussion.
I can see a question from anonymous attendee. If a couple enter from India, and one family member's health worsens, will they be able to remain in the UK? I'm assuming, anonymous attendee, that this is a couple who have come for a family visit to visit somebody who would potentially otherwise be their sponsor. And so we've got one parent who would then say there's been a sudden incident, we're applying leave outside the rules with reference to TZ, reference to Appendix ADR 7.1. What about the other one? Is the other member of that couple expected to leave? And the answer is no. When you look at the appendix, the ADR appendix, if it's one person in the couple who's unwell, sufficient to meet the requirements, then their partner can come too. So I would expect the same to happen with an in-country application. And then I think there's one for you, Richard, on the EUSS appeal rights, very far outside my wheelhouse.
Ah, right. So is this in the Q&A, not the chat box?
Yeah, the Q&A.
Q&A, okay. Oh, please can we discuss my questions on the EUSS appeal rights? Oh, the Irish EEA national requirement to exercise treaty rights. Okay, I think this is further on up quite a bit. Oh yes, here we are. Another question which both the upper tribunal and the first tier have not answered is, if an Irish citizen needs to exercise treaty rights for 5 years before he or she can sponsor a non-EEA national spouse, to enable such a person to acquire permanent residence in the UK. So an Irish, yes, I'm not really too sure about this because, of course, Irish citizens can live in the UK with no restrictions at all. They don't need to be exercising treaty rights to be here. They have a special position in UK immigration law. There was some litigation a while back about a person from Northern Ireland who was both British and Irish, had both nationalities, and whether she could rely on her Irish nationality to sponsor a Nigerian overstayer. I think it was something like that. And it eventually was held that if she was British and living in the UK, she couldn't use her Irish citizenship in preference to her British citizenship for the purposes of EU law. But if somebody is just Irish and living in the UK, can that person be said to be exercising treaty rights? Especially now that well, actually, this is one which I don't feel very confident about answering. Anybody else? I haven't actually heard anything being raised about the position of Irish citizens living in the UK and the rights that they may have under the EU settlement scheme, because they are regarded as settled in the UK as soon as they step off the plane. So they don't need to apply for the settlement scheme at all. So, my provisional view is that an Irish citizen in the UK wouldn't really be eligible for the settlement scheme, and so couldn't sponsor anybody else under the settlement scheme. Maybe that's why this hasn't cropped up at the upper tribunal before. Yes. Well, is there anything else that still needs answering?
I think there's one just above the Irish question, which is, can we discuss the rights of appeal of EEA nationals facing deportation when they had USS leave, but the conduct occurred after 31st of December 2020? What rights do they have under the withdrawal agreement?
Well, as far as deportation is concerned, they don't enjoy the same rights as they would if the conduct took place before the end of 2020. They're stuck with the British deportation rules, aren't they? So they can't rely on grounds of public policy, public security, and public health, and so forth. So they're subject to basically the same deportation provisions as non-Europeans. I think if their offences were committed, some before and some after the 31st of December 2020, they can rely on European law, because some of the offending took place before the cut-off point, the end of the transitional period. But if all of the offending took place after the end of 2020, they're stuck with British deportation rules. I think that's it, isn't it? Yes. Well, folks, I think we've probably done enough to satisfy the needs of the audience, who've been very patient if they've lasted this long. But if they have, they will have gained a great deal of useful information from being here today. And I'm sure they will be very grateful to all of our speakers who've really given a great deal of very useful information and conveyed it in an interesting way. So I think most of us have managed to stay awake and and lively throughout. So thanks very much to all our speakers, and of course thanks again to you who've diligently sat through our talks, and thanks to our host Wasanta Tenakun and his team who put on these webinars 3 times a year, and we hope that at least some of you will want to attend the next webinar, which will be early next year. So on behalf of everybody who's been taking part as a speaker, thanks again, and goodbye till next time. Bye-bye, everyone.
Everyone.
Bye now.